And we are recording. Lila, would you like to introduce, or Chair LaHood, would you like to introduce the hearing?
I would be happy to. Welcome, everyone. This is the Sunshine Ordinance Task Force Compliance and Amendments Committee meeting. This is our remote regular meeting on May 25th at 4:30, May 25th, 2021 at 4:30 p.m. The public call-in phone number is 415-906-4659. The meeting ID is 544-958-602#. If you wish to make a statement during general public comment, please press *6 and unmute your telephone to speak. Please press *6 to mute your telephone once you're done with your statement. In accordance with Governor Newsom's executive order number N3320, declaring a state of emergency regarding the COVID-19 outbreak, and Mayor London Breed's proclamation declaring a local emergency issued on February 25th, 2020, including the guidance for gatherings issued by the San Francisco Department of Public Health Officer, aggressive directives were issued to reduce the spread of COVID-19. On March 17, 2020, the Board of Supervisors authorized their board and committee meetings to convene remotely via Microsoft Teams and will allow remote public comment via video conference. Members of the public may participate by phone or may submit their comments by email to cheryl.leger@sfgov.org. All comments received will be made a part of the official record. Sunshine Ordinance Task Force agendas and their associated documents are available at sfbos.org/sunshine. Again, the public comment call-in number is 415-906-4659, meeting ID 544-958-602#. As the COVID-19 disease progresses, please visit the Sunshine Ordinance Task Force website regularly to be updated on the current situation as it affects the legislative process. Meeting decorum. Any member of the Sunshine Ordinance Task Force may call for decorum due to disorderly conduct of meeting participants. Persons who engage in threatening and or menacing behavior may be asked to leave. Ms. Leger, please call the first item.
Item number 1, call to order, roll call, and agenda changes. Roll call. Member Neighbors.
Present.
Member Neighbors present. Member Wong.
Present.
Member Wong present. Chair LaHood.
Present.
Chair LaHood present. We have a quorum. I am not aware of any agenda changes. Are any of you aware of any? Victor? I haven't gotten any.
Not any agenda changes. I know we have a question coming up regarding a request to continue something, but that's not an agenda change. We also had a request to take a 10-minute break. Was that after item number 6? Is that correct?
Yes.
Okay. So for everyone who is currently on the call, we will be planning to take a 10-minute break after item number 6, which is file number 20079. We'll announce that again as it is happening. If that's it, let's call the next item, please.
Item number 2, approval of the April 27, 2021 Compliance and Amendments Committee meeting minutes. Sorry, it says 20. It should say 2021.
Members, do we have any comments on the minutes?
No changes from me.
Member Neighbors, you had a suggestion?
No changes that I see.
No changes. Okay. Member Wong?
Nothing from me.
Okay.
I have one thing, and I just noticed this, and perhaps we can confirm because I believe he will be here today. I have not looked this up, but I thought it was, I think if we could confirm the spelling on Mr. I thought it was Wisinski.
Winisky.
It's Winisky. It's not Wisinski?
No, it's Winisky. I think that's how his name is. Hang on a second. I can check it on the directory.
Okay. And I only asked because I had listened to an audio file, but it could be that others were. I just want to make sure that we have people's names spelled correctly.
Can you hear me?
Yes.
Oh, well, I'm that person, so I can help you.
Can you tell us how to spell your name, please?
Sure. It's Wisinski.
Okay, so it is Wisinski.
Correct.
Okay.
Oh, I'm glad you said something, sir.
Yeah, no problem.
Or
So, Ms.
Lila.
Leger, if you don't mind doing a find and correct throughout, that would be great. And Mr. Wisinski, thank you for confirming that for us.
No problem.
Got it.
Okay. Members, if we don't have any other internal changes, I'd like to open up the minutes for public comment.
I believe you can make that motion, and then we can comment after the motion.
Thank you. Sorry, you'd think I would remember this. I will make a motion. Do we have a second? A motion to approve the minutes.
I second.
Okay. Let's
Minutes.
open that up for public comment.
Minutes with amendments.
With amendments, yes. With the correction of spelling of names.
And member neighbors, you second?
Yes, ma'am.
Okay. Are there any members of the public wishing to make public comment? Please identify yourselves. We'll create a queue, and then Ms. Leger will let you know when she's ready with the timer.
Yes, please. Peter Warfield.
Okay. Is there anyone else who'd like to make comment after Mr. Warfield?
Anonymous, please.
Okay. We have Mr. Warfield and Anonymous. Is there anyone else who would like to be in the queue? Okay. I'll ask one last time at the end. Ms. Leger, could you tell us when you're ready, and we'll let Mr. Warfield begin.
Go ahead, Mr. Warfield.
When do I start now?
Go ahead, yeah.
Thank you. This is Peter Warfield, Executive Director of Library Users Association. We can be reached at libraryusers2004@yahoo.com, excuse me, and at P.O. Box 170544, San Francisco, California 94117-0544. I give these details as I have a number of times in the past, generally at each time I comment, actually, because I think it's important in a time when public process is completely different from how it is in person. In person, folks can go up to each other and exchange phone numbers, exchange contact information, discuss, and so on. All of that is cut out under COVID-19 restrictions. So I think it's important enough to take the time to take time away from my 3 minutes of comment to say those things. First of all, I appreciate that at least on the first mention here, you've gotten most of it correct. You have not got the zip code with the extension, and that's part of the zip code, 94117-0544. So I certainly would like that correction. In a previous appearance, the P.O. Box was actually wrong, and they did nothing to correct it when it was noticed later in the meeting. And that was a big disappointment. I have been giving this information at every public comment that I've made, and I have yet to hear any discussion or explanation why it has been initially, everything has been left out but my first and last name. Then there was, at some point, eventually there came to be a little bit part of the contact information. In one case, the P.O. Box, which is the least likely to be used, very selectively and very arbitrarily, and certainly omitting what I've said, and no reason given at any time. Now, you're not legally required, but I think for an open government outfit, it ought to be understandable
30 seconds.
where and how these decisions are made. And I think I'm getting cut by 6 seconds on the timer again.
Using my timer, Mr. Warfield.
Pardon?
I'm using my timer, Mr. Warfield. I go
Well,
by.
you're starting it early.
Okay.
That's what's happening. And that happens repeatedly.
Okay,
I'm not done yet.
We need to stop. This is Chair LaHood. We need to stop the conversation. Thank you, Mr. Warfield.
I would like to finish my comment. I have comment for the rest of my time, and that is much of the comments are bowdlerized and drained of their particular meaning and their specificity, and I think that's unfortunate. I wish I had the time to explain.
I think your
what I
time
mean
is
by
up.
that. Thank you very much.
Thank you. Anonymous, Ms. Leger will tell you when she's ready with the timer.
Are you ready, sir?
I am.
Go ahead.
Thank you. First issue is actually Mr. Warfield's email address is misspelled on the place where you put it. It says library users 204. So I'm assuming the first word has a typo and it should be just library. And the second thing I wanted to note about these minutes was that it says that the October 27, 2020 meeting minutes were continued, but I don't see the approval on today's agenda. So it seems like at some point those minutes still need to be approved. Thank you.
Do we have any other members of the public wishing to make comment on the minutes from the April meeting?
General public comment will follow after this, correct?
General public comment will follow later. We are currently taking comments on the minutes.
Thank you.
Okay, hearing none. I do want to address the issue of the, Cheryl, do we need to, I'm looking at the October minutes. We continued to the call of the chair. I'd like to request that we approve these minutes, and if we still need to approve the October 27, 2020 minutes, if we could just put those on the agenda for our next meeting.
What I only recently was in touch with Mr. Hillier about the changes in his testimony. He got back to me, and so it wasn't timely to put it in the agenda. It was too close to everything that had to be done. So I had planned to put those minutes in there in the June. I had planned to do that.
That sounds great. I appreciate that, and I think that I appreciate all of the public comment. I would also say that if we could correct the apparent typo in the email address.
Got it.
Yeah. And members, is there any further changes that you think we need to make at this point, or are we ready to vote?
We're ready to vote.
Okay.
Chair LaHood?
Aye.
Chair LaHood, aye. Member Neighbors?
Aye.
Member Neighbors, aye. Member Wong?
Aye.
Member Wong, aye. The motion to approve the April 22nd, I believe, was it? April 27 Compliance and Amendments Committee meeting minutes are approved with amendments.
Thank you. I appreciate that. Please call the next item.
Item number 3, public comment. Members of the public may address the committee on matters that are within the committee's jurisdiction but not on today's agenda.
Okay, so now we will take a cue for general public comment. Again, these are items, anything you would like to bring up that is not otherwise on today's agenda. Who would like to make public comment?
I'd like to make public comment.
Okay, you'll be the first speaker. Who else would like to make public comment?
Anonymous.
Peter Warfield.
Okay, I heard the first speaker, then I heard Anonymous, then I heard Peter Warfield. Is there anyone else who would like to make public comment? Okay, I'll ask again at the end, but right now it sounds like we have 3 speakers, and I think it should be clear the order you're in. The first speaker, who was unidentified, anonymous, and then Mr. Warfield. Ms. Leger will tell you when she's ready with the timer. Thank you.
Okay, and I just want to make it clear to people that I'm using my own timer to time people, and that is what I go by. I can't help it if your timer says you have 5 more seconds. Mine doesn't, and this is the timer that the committee is using. So just please bear that in mind.
Thank you.
Okay, we have a first speaker.
Tell me when to start.
Oh, go right ahead.
Okay, the San Francisco Sunshine Ordinance Task Force Public Complaint Procedure starts with Section A, inquiries in person or by phone. It is the goal of the SOTF to help the public gain access to public records and meetings. The staff of the SOTF will therefore work with members of the public to help achieve such access in order to avoid the need for filing complaints with the SOTF. Unfortunately, I believe the administrator is working contrary to the goals of the law. I wish to remain anonymous. This is a right specifically guaranteed in the San Francisco Sunshine Ordinance in all communications with the task force. This is an arrangement that extends to complainant phone numbers. During last week's Sunshine Ordinance Task Force Complaints Committee on Tuesday, May 18th, Cheryl Leger, the task force administrator, stated that she works 40 hours a week for the task force. As an aside, it's worth noting that the task force administrator, according to reliable public sources, earns about $140,000 a year, including benefits. Communication with the administrator has become a great deal more difficult, sometimes impossible, since she stopped answering her office phone during business hours. On or about December 2020, a date that coincides with a complaint filed against Cheryl Leger with her boss, Ms. Angela Calvillo, the clerk of the Board of Supervisors. Those things strangely coincided. Cutting off telephone access. Thus it has become impossible for anonymous complainants such as myself to speak to the task force administrator. Given the administrator's critical role in receiving, vetting, and processing public records requests, I believe Cheryl Leger should set aside a dedicated 2-hour time slot each week during which she will answer her phone, her office phone, which may or may not connect to her cell phone. This is an arrangement that worked with considerable reliability for all of 2019 and virtually all of 2020, before and during the COVID-19 pandemic. For the record, the administrator's office phone number is 415-554-7724. This also involves problems with email.
Seconds. 30 seconds.
This deterioration in access only exacerbates a digital divide that cries for fixing, especially this body of government.
Thank you. And we'll be ready soon for our next speaker. Anonymous, Ms. Leger will tell you when she's ready with the timer.
Sure, thank you.
Go ahead, sir.
Thank you very much. I can't say I have any personal experience regarding phone calls or the administrator's responsiveness to them, so I'm not going to comment on that. But I do think it would be a great idea for the SOTF to have office hours via its administration for people who don't want to use email and or can't use it or whatever, or don't have another connection to the SOTF except by phone. I think that's a great idea. The Office of the Clerk of the Board, I believe, does it for the whole clerk of the board, and I think it would be great for SOTF to do it with a fixed time each week also. The main thing I wanted to ask is when the SOTF is going to schedule Mr. Hooper's various complaints, 19061 and 19062. I think these complaints have been sitting around for a very long time. If you look at those files, there is absolute hard evidence now that the city did in fact not provide all of the records. And these cases need to be scheduled before the full SOTF as soon as possible. It's not right that he I think it's one of the oldest cases still completely open, and these should be scheduled as soon as possible. Thank you.
Thank you for your comments. I believe we have Mr. Warfield as our third speaker. Ms. Leger will tell you when she's ready with the timer. When she tells you to go ahead, that means she's starting the timer. So just go ahead and speak.
Go ahead, sir. Mr. Warfield?
This is Peter Warfield, Executive Director of Library Users Association. Library Users 2004 at yahoo.com and P.O. Box 170544, San Francisco, California, 94117-0544. It's disappointing to once again be basically ignored with questions about how decisions are made or why on correctly showing what has been requested to be put in the minutes or what has been said in person. I'm glad that you took the anonymous person's correction of our email address, but that still leaves my request for a correction to the mailing address. And it seems as though every time my address appears, and library user's address appears, that there's something wrong with it. Is this a game? It is certainly not something that gives one faith in the effectiveness of the Sunshine Ordinance Task Force or its particular interest in correctness. I do want to speak in agreement with previous speakers with regard to administration. I've certainly had difficulty getting through and getting response to talk with the administrator. At one point, there were multiple emails and 5 weeks of phone calls without having a successful callback, except having some responses that basically said why there was a delay or why there was a problem. Not that any of those were incorrect. And that leads me to something I've said before, and I think that the others would either have already said or would agree with, and that is I'm troubled by the lack of support. Actually, Supervisor Peskin talked about that, that the Sunshine Task Force, has been getting. And I think that under the law, you are required to get not only an administrator, but the necessary support that such an administrator would need. If that person needs extra help from individuals or whatever, supplies, anything, I think that she should be provided those things. There's also supposed to be a lawyer, and we don't see that at all. What happened to the lawyer? There doesn't seem to be one around. We sent to the task force members today a request to try out making public comment at a meeting, and we think that's very important for you to understand what the arguments will be next week at our complaint regarding public comment. Thank you very much.
Thank you. We appreciate your comments. The one thing I will say, the request for corrections will apply to the email and the mailing address. We do strive for accuracy in our minutes, and I think Ms. Leger is very attentive to that. And that is all that I will say on this matter now, but thank you everyone for your comments. We do listen to what you say and take them into consideration in all of our work. I think we are ready for the next item. So Ms. Leger, if you could call the next item, please.
Item number 4, file number 19145, hearing regarding request for reconsideration, complaint filed by Chris Kors against the Police Commission. Against the Police Commission, the Sunshine Task Force found that the Police Commission did not violate Administrative Code Section 67.5 and 67.21 for failing to respond to a public records request in a timely and or complete manner. This matter has been heard and a decision was made, and now we are here to decide if there is enough evidence to go forward for a reconsideration by the task force and a new vote.
Okay, thank you. I'd first like to ask, is the petitioner here?
Yes.
Okay. And is the respondent or a representative here?
Yes.
Okay. So thank you for reading the summary. As we know, this was, we had a decision from the full task force. This is a request for reconsideration. What I'd like to do is, I'd like to give, and actually I'm going to ask Victor, unless, is there a specific limit that we are allowed with a reconsideration, or is that to the discretion of the chair?
It's this is a committee level hearing, so it's at the discretion of the chair if you want to allow a certain amount of time for each party to make a presentation.
Mm-hmm.
And we should be limiting our discussion to what is the new information that is being presented and if that will affect the previous decision.
Okay.
We should not be reconsidering testimony that's already been provided.
Exactly. Thank you for clarifying that. That is very helpful. So, Mr. Kors, I would like to, I'm going to say I'm not going to set a hard time limit, but I would ask that you please be concise and tell us what new information you would like to provide to this committee so that we can consider whether this would warrant a new hearing by the full task force. And then I would like to give the respondent an opportunity to respond to that. And again, I'm not going to set a time limit, but I would ask both parties to be concise in their presentations. Thank you.
Lila, do you want me to put the timer on?
Mr. Kors, if we were to say about 5 minutes, do you think you could present your information in about 5 minutes?
Yes.
Okay. Then, Ms. Leger, let's just let Mr. Kors speak, and he will tell us when he has finished.
Okay.
Thank you.
I have a timer, but that's okay. Mr. Kors, you are free to speak at any moment.
All right. Yeah. When I sent in this request for reconsideration, I also sent in a link regarding SB 1421, and in that it states that on duty. Well, I'll just read it word for word. On duty conduct. This statute covers off duty conduct, and it's written, in bold print right there. If the off duty conduct relates to report, investigation, or findings with a disposable category of the peace officer records. If so, then follow all other rules outlined herein. So I think it states right there that just because I was off duty during this incident, it's actually covered. Off-duty incidents are covered. In the last hearing, the interpretation of that law was that it should not be covered. Secondly, and on page 444 to 445, the evidence packet, it documents I requested this as a public records request, and I received it as a public records request on September 13th, 2019. Pardon me. Finally, track one of my hearing is disclosable as it was provided to me as a public records request, and it was part of an agendized public hearing, and track one is altered. I was at the hearing, so I know what was said in that hearing. You can listen for yourself. After my attorney says he is, basically there's an anomaly.
What you saw on a page status is your client called 911.
And that anomaly is where important dialogue is missing. Some of this missing dialogue was excised from the city prosecutor Ashton Worsham's testimony. The commission is stating that it's not altered. Both of us cannot be telling the truth. One of us is lying. What's unique about this situation is that the SOTF can determine who is telling the truth. All they have to do is to personally and physically inspect the digital original for integrity. Time codes, digital timestamps, date last modified. It's that simple. I'm requesting that the SOTF vote to make this transparency happen. That is pretty much the gist of it. And I would like reconsideration. Thank you.
Thank you, Mr. Kors. Is there anyone else here speaking on your behalf, or is that everything that you have to present to us?
That's what I have to present.
Okay. And for the respondent, who's here to speak in response?
Hello, excuse me. It's Sergeant Stacy Youngblood from the Police Commission Office.
Okay, Sergeant Youngblood, I'd like to do the same here and just give you. Do you think you could give your response in, I'll say up to 5 minutes?
Yes, ma'am.
Okay, please go ahead. We're not going to use a timer, but if you could be concise, that would be helpful.
Okay. So I just tried to respond. I just took quick notes here from what Mr. Kors was saying. Regarding the SB 1421 applying to off-duty, SB 1421 only applies under 4 categories. So that would be, in this case, if they're trying to say that this was a use of force, a use of force is not defined as a traffic accident. Mr. Kors would have to have purposely used his vehicle to hit the people to be considered a use of force, but this was a traffic accident, so it is not considered a use of force. Therefore, it is not an SB 1421 record. When he says it was given to him as a public records request, that is not true. It was given to him as a former employee requesting their personnel file information. I have emailed Mr. Kors numerous times explaining to him, as I have said to the Sunshine Task Force numerous times, that it was provided to him not as a public record, but as an employee asking for their personnel records. That's how he has the documents that he has. I also had a phone call with him prior to him asking him if the file is too large to email to him. So what we did is I uploaded it to, it's called the GovQA, it's our public record software that I was able to upload the document and send it to him that way. That way he was able to get it. I understand that using that software, it says in the letter that this is provided to you as a public record. It was explained to him before, it was explained to him after that this was a personnel record and how it was being given to him. His assertion that the record was altered, or that we somehow altered the recording, saying that one of us is lying, I think a more concise way to say it is one of us is mistaken. I am not lying that we have altered his audio recording. I wouldn't know how to alter it. It has never left the Police Commission office. We do not have software that would alter a record, nor do we have reason or want to alter it. And as far as he told us that he had hired an expert, and this expert was afforded the chance, along with Mr. Kors, to come to our office to where he could actually look at the actual physical thumb drive that it was on, examine it in the office. He was just not allowed to take it from the office. We gave him the opportunity to schedule that appointment, and they never came. So we have done everything that we can to try to alleviate his assumption that it has been altered, but we have not been taking up on anything that we have tried to provide him in order to do that. And I think I've hit on everything that he touched on, so I think I'm done.
Thank you. Sorry, I was on mute. Thank you. We appreciate that. Members, I will open it up to you in a moment, but I have a question for Mr. Kors. Mr. Kors, when that offer was made to have your expert come into the office, was that something that you wanted to do or would still consider doing, or can you tell me why that, if that was not an acceptable response, if you could tell me why?
Basically, what they offered was that we come in there and listen to the recording. We couldn't touch anything. We couldn't inspect anything. Just sit there and listen to it. We already have the recording they gave us. If we went there, it would be the same recording.
I'm not going to fly fly a bunch of experts out there just so they can listen to the same altered recording without having any chance to analyze it. Listening to it is one thing, but actually analyzing it forensically is another, and that wasn't allowed. They weren't allowed to forensically analyze it. Science, we just needed the science behind it. If we can't test it, there's no science. So that's where it ends.
Okay, thank you. Members, I'd like to offer you the chance to ask questions. Do you have any questions?
Yeah, I'm trying to make sure I have this straight in my head. My memory of our kind of discussion around this and our decision-making process at the full board, if I remember correctly, it centered more on whether or not the closed session was to discuss personnel matters, and whether that was a personnel issue, whether there were concerns about impending litigation or not, and how that played out, and then whether there were matters of, that could be considered maybe attorney-client privilege. That the issues were about whether but basically what it boils down to is that the content of the closed session was being defined by Officer Youngblood as a kind of a secondary personnel record, and that was disputed. So I'm guessing my question is there any new information on those issues, since those seem to be the deciding issues?
So are you asking Mr. Kors, or are you asking us for discussion?
No, I'm asking Mr. Kors and also Officer Youngblood, because I didn't hear those issues discussed in their presentations. And it seemed like those were the most salient issues when we were making our decision prior. So, Mr. Kors and Officer Youngblood, is there any additional information in terms of how you're defining the closed session, whether it's a personnel record or a disciplinary hearing, if there are any issues around us being able to apply or not apply statutes that have to do with whether or not there's potential litigation, or if there are any attorney-client privileges in play.
Let's hear from Mr. Kors first, since he is the one who is asking for the reconsideration. I don't think Sergeant Youngblood, he's here as the respondent. So, Mr. Kors, if you could respond to Member Neighbor's question, that would be great.
Sure. Let's see here. Penal Code 832.8A4. Disciplinary records are a subset of personnel records. Therefore, if the police commission is admitting these are disciplinary records, they are personnel records and may be subject to SB 1421 Penal Code 832.7B. So that's the argument for that. And as far as what it's under, at the last hearing, Sergeant Youngblood stated that track 1 was held with the San Francisco Police Department personnel file. Track 2 of the audio recording was held with the San Francisco Police Commission disciplinary file. Then Chair Wolf correctly determined that it was disclosable. Only then does Sergeant Youngblood change his story again and then state that it is actually held within the San Francisco Police Commission personnel file. I have the audio recording of that. If you guys want to hear it, you guys can, but I'm telling you how it is. That's exactly how it went down. And the amount of times that his story changes is just unbelievable. So there you have it. There's the penal code in the first part and how it all went down in the second part. So that's it.
Member Wong, do you have any questions or things that you would like us? Do you have questions for Mr. Kors or Sergeant Youngblood, or questions that I have some thoughts about things that I would like us to discuss, but I want to make sure that we have a chance to ask them our questions.
No, I don't have any questions.
Okay. One thing that, with this case, it was a close vote. And some of us had heard about aspects of this case over several committee hearings, although other members of the full task force maybe were hearing this case for the first time. I think we were mixed on our interpretation regarding the, and this is what Mr. Kors brought up at the beginning, whether this applies to off-duty conduct or just to information for on-duty conduct. And then, as Sergeant Youngblood said, the other point is, he said the definition of use of force. It's not proactively defined as a traffic accident, but it's not excluded. And I don't know. And does that raise questions for you? Whether does it raise enough questions where you think that we should ask the full task force to consider this again? Did we collectively, did we have enough information? Was enough information presented at the last hearing? Was it fully presented to the full task force, or do you think that there are aspects of this that have not been considered fully?
This is Member Wong. I find that, in my opinion, I don't see this as new evidence. I think we discussed SB 1421 and the possibility or the difference between it being a public records request versus a personnel request. We also discussed use of force and also discussed on-duty versus off-duty behavior. But that, I think, is a sub-bullet of whether or not it's a public records request or not. We also discussed, that this was part of a closed session of the police commission. So for me personally, I don't see that this is enough new evidence to bring this to the full task force again. I did note, though, that the vote was close, and that many of the members were not part of the task force when we first discussed this at both the Compliance and Amendments Committee and also, I think, the full task force. Actually, I think we discussed it in October at the full task force, and then we also discussed it in November at the Compliance and Amendments Committee. So I don't recall. I think we discussed the legal memo that we also received from our attorney, from the city attorney. So yeah, I feel like a lot of the information has already been presented.
Yeah, I mean, I find this is challenging because it's a complicated situation, and we are here to help the public gain access to public records and make sure that they have access to meetings. And we know that the Sunshine Ordinance goes steps beyond the California Public Records Act. So it reinforces it, and it gives even more access. And this is challenging. And yes, it was heard by the full task force. and we consider all of these aspects, I am concerned that we are applying our best judgment in each situation. Do we have, did all of us have all the information we needed to make this decision? I guess if we're saying, what is the new information presented here? And I guess we're hearing from Mr. Kors, not information that we hadn't heard before, but perhaps it sounds like he felt that we did not consider strongly enough certain aspects of his case. I don't know. Member neighbors, do you have anything else to say about this, or does either of you want to make a motion on this, and then we can open it up for public comment as well?
This is Member Neighbors. I'm so glad to hear you saying, Chair Hood, that the importance of reminding us all that we are here to make sure that the public is represented in their open records requests. And I think this is particularly, I know that we are all particularly concerned about public records in policing, and that we care very deeply about that, and that we want to see SB 1421 fairly applied, and that we want to make sure that we're operating within the spirit and intent and letter of that policy, with the added provisions of the Sunshine Ordinance. In my mind, we haven't heard new information today that was information related to where we were at with the decision-making point. That doesn't mean that, to me, that that is not the same thing to me as saying I don't believe there's something missing from the tape, or that I don't believe what Mr. Kors is saying. It's not that at all. It's just that within our own jurisdiction and what we can do, I'm not hearing new information or evidence that lends me to think that we need to go back and rehash. And when I think about the closeness of the vote, I'd have to review it, but I don't think that it was necessarily split in terms of new members and older members. Mm-hmm. I think that there were some older members as well who voted along the lines of closing the case file. So in my mind, I think we've just we don't have new evidence, and so we can't act on it to bring it back to the full committee.
Okay. Oop. Oh, the video jumped for a second. Okay.
Would you like to make a motion? This is Victor Young,
Yes.
Assistant Clerk. My feeling is that maybe a motion should be made and public comment can be taken, and additional discussion after that, because it sounds like there's two members who are stating that they don't believe there's new information, and maybe that could be the motion to find that no information was provided and reconsideration is not justified, or something to that effect.
Victor, I have a question, a procedural question on this. If we were to proceed with that, is there any, if Mr. Kors found other new information, is there a potential to appeal the appeal, or is this the last step?
This will need to this recommendation will get sent to the full task force for their final approval. Mm-hmm. And between now and then, I assume he could bring forth additional information, but our procedures don't take that into consideration about how many times they can ask for reconsideration. It only sets a 30-day time limit from the date of decision.
So in other words, if new information were to emerge The door is not permanently closed. Where it would just be, do we have new information at this time?
No, he has a time limit. That's what Victor said. There's a time limit from which he can make tell us that he wants a reconsideration. It's 30 days from the vote, and he made that he was timely in making his request. So that's the way it is.
And then this will go to the whatever we decide will go back to the full task force. So there is another step in this process.
Yes, the full task force will need to make the final decision. However, they will have your recommendation if you have one.
Okay. In that case, I would like to ask this committee, does one of our committee members have a motion to make on this?
Yes, and just to clarify, the time frame for requesting reconsideration is 30 days from the date that we issue the order of determination, which did occur. So this is the only opportunity at this point in time to ask for a reconsideration. Otherwise, it can go on indefinitely. And so I believe the last chance will be between now and the time it's scheduled for the full task force for any additional documents to be submitted.
So it would have to be between now and that hearing.
Yes.
Okay. Okay. Thank you. Thank you both for the clarification. Committee members, would one of you like to make a motion?
Sure. This is Member Neighbors, and I move that based on a lack of new information, we recommend to the full task force that we deny this request for reconsideration.
Do we have a second on this motion?
This is Member Wong. I will second that motion.
Okay, we're going to open this up for public comment. We'll create a queue, and then we'll give everyone a time limit. Who would like to make public comment on this motion?
Anonymous, please.
Okay, I heard anonymous. Is there anyone else who would like to make public comment on this motion for parties not involved in the case? Okay, I'm only hearing anonymous, but after anonymous speaks, I will ask again. Ms. Leger, when you're ready with the timer, if you could let anonymous know, and we will take that comment.
Sir, are you ready?
Yes, I am.
Go ahead.
Thank you very much. This motion is wrong, and you should not vote for it. At least one and possibly two of you at the full task force incorrectly decided that off-duty conduct of police officers was not within the legislative intent of SB 1421, and therefore the record that Mr. Kors has presented to you of the Police Commission's own understanding, own interpretation of SB 1421 of on-duty conduct being within the scope of disclosable police misconduct records is new evidence and could swap even one vote. And since that vote was 6-4, if even one person changes their mind based on that, that would no longer find in favor of the city, as you did. Furthermore, I think one of the big problems here is no one is holding the police commission to specific citations of law. Where is the police commission citing that use of force has to be intentional? If you accept this requirement, you are changing how police misconduct records will disclose, not just of potential misconduct of Mr. Kors, but of every police officer, which is why I'm arguing about this. There is no requirement. If you accidentally shoot someone, you still have to produce those records. And if you go along with this argument, which has no legal citation, you're excusing that. And finally, they argued that they could have an attorney-client privilege in a part of a Brown Act closed session that was not noticed under that provision of the Brown Act. That is prohibited by the Brown Act Government Code Section 54956.9. If they cite it as a personnel file exception, which they did in the original agenda, then that's all it is. You cannot use attorney-client privilege to exempt personnel closed session hearings. And this, I don't believe, was ever considered by the full task force. Finally, the argument that disciplinary records are separate from personal records is false. According to the definition in SB 1421, they are one and the same, and they are disclosable if you believe there is a great bodily injury occurring here. So I urge you to vote against this motion. This is a harm not just to this records disclosure, but to police misconduct disclosure everywhere. Thank you.
Thank you for your comment. Do we have anyone else wishing to make public comment? This is for members of the public who are not involved directly with this case.
Yes, this is Stephen Malloy. I wanted to make a short public comment, please.
Okay, Mr. Malloy, thank you. One moment, Ms. Leger will tell you when she's ready with the timer.
Are you ready, Mr. Malloy?
Okay, thank you. Yes, I just wanted to, in support of what Anonymous had just said, mirror that, and in support of the charging party that's bringing forward his claim, that I think you should reconsider to have this go back to the full task force, particularly to Member Wong's point that some people may not have been on it at the time that that original vote took place, to allow them, all of you collectively, to review this. I think in support of the charging party, you know, these processes are very stressful. I think in support of what one of the other members mentioned about policing today, we should always do everything we can to increase the bandwidth. And if, to Anonymous's point, this is not within the law, and I do not believe it is, I believe he's correct that disciplinary records are included as part of personnel records and therefore are disclosable, that you should allow this to come back to the full task force for a final discussion before closing it out today. Thank you.
Thank you for your comments. Is there anyone else who would like to make public comment?
Yes, please.
Okay, one moment. Ms. Leger will tell you when she's ready with the timer.
Go ahead, Mr. Warfield.
Peter Warfield here, Executive Director, Library Users Association, Library Users 2004 at yahoo.com, and also P.O. Box 170544, San Francisco, California, 94117-0544. I would like to echo what Anonymous, and I'm sorry I didn't catch the name, I think Mr. Malloy said a few moments ago. I seem to remember also saying something similar at a previous meeting, where it seemed to me that there was a lack of citation of specific law that requires or allows things to be exempted. And I think basically that Sunshine requires citations of specific sections of the law. And so I would also, in case of any doubt at all, and I think there's a strong case for rejecting the motion and taking another one instead, saying that it should be decided by the full task force. I'm hearing some noises. Something going on? So I think that the motion would be, it would be apt to, well, if there's even any doubt, to make the motion the reverse, and that is to leave it, to go forward to the Sunshine Task Force for the full task force to have a full discussion and a full consideration, and also for the material that's in the file to be more fully considered in sort of the fullness of time. Thanks very much.
Thank you for your comments. Is there anyone else who would like to make public comment on this matter? Okay, hearing none, I'm going to close public comment.
No, Anonymous. Hello.
Oh, sorry. We could not hear you. I'm hearing, is this a new person who wants to make public comment?
Yes, ma'am.
Okay, thank you. Hold on one moment. If there's anyone else who has been trying to be heard, we're going to let this speaker make public comment. And then remember to unmute yourself, press *6. We also ask that you then remute yourself and press *6. Otherwise, we get background noise. So one moment, Ms. Leger will tell you when we're ready to take your comment and invite you to speak.
Are you ready, sir?
Yes, ma'am. Yes,
Go ahead. Go ahead.
Okay, my comments are really relevant to public access to records. You know, previously in one of the meetings, the police commission stated they have no chain of custody logs for the tape. So how would anybody possibly even know if something was taken out, altered, or not? Also, no one has ever seen a copy of the court reporter's transcription notes. So how would we really know, relevant to the public, what's going on here? I have real concerns what's happening. The second concern is why doesn't the police commission release these tapes? What are they hiding? At least allow the SOTF members to digitally analyze this track one tape. If there's nothing to hide, why aren't we doing that? Then I have another question about the police commission's witness. He has misrepresented and lied so many times. Why aren't there other witnesses brought forth, at least who attended that original hearing? Sergeant Youngblood wasn't even at that hearing. What about Ashley Worsham? What about the court reporter? I just have some real concerns what's going on here. And all the times that the police commissioner's witness has changed his mind or altered his story. This doesn't seem like a true way to give the public access to real information or a true way to resolve any police activity problems. I have major concerns on that, and that's pretty much my comment. Thank you.
Thank you for your comment. Is there anyone else who was having trouble unmuting before who would like to make public comment on this matter? Remember to unmute, press *6. To mute yourself again, press *6. Okay, I'm not hearing anyone who wants to make public comment, but I do see someone who is unmuted, whose phone number ends in 05. If you could please mute yourself if you're Thank you. Okay. Is there anyone else who wanted to make public comment on this matter?
Victor, is there any way you can mute all this noise?
Okay.
All right. Thank you.
Okay. That was last call on public comment. I am bringing this back to the committee members. Committee members, any other discussion based on public comment? Okay, I think we are ready for the vote.
Member Neighbors?
Aye.
Member Neighbors, aye. Member Wong?
Aye.
Member Wong, aye. Chair LaHood?
No.
Chair LaHood, no. The motion to move that based on the lack of new information to present to the Sunshine Ordinance Task Force, the Compliance and Amendments Committee is denying the request for reconsideration.
Okay, thank you.
I just want to clarify, the committee is not actually denying it. They're recommending the denial and sending it to the full task force for confirmation.
Right. Thank you. Thank you, everyone. Thank you, Mr. Kors and Sergeant Youngblood, and for all of the public commenters. We appreciate your participation in registering your thoughts on this matter. Ms. Leger, we're ready for the next item.
Hang on a second. Hang on a second. Item number 5, file number 20123, complaint filed by Maya Zubkovskaya against the Department of Emergency Management for allegedly violating Administrative Code Section 6724 D2 by failing to disclose certain portions of the law enforcement information.
Okay, thank you. Is the petitioner here today?
Yes. Hello.
Okay. Thank you. Thank you for being here. Do we have someone representing the respondent?
Yes.
Hello, I'm sorry, go ahead.
My husband, Douglas Carlson, will be representing me.
We're the petitioners, Doug Carlson and Maya Zubkowska. I think we got confused at the unmute moment.
Okay,
Didn't
so
mean
we
to interrupt the respondent.
Okay, we have the petitioners. Is the respondent here?
Yes, the respondent is here.
Okay, great. So what we're going to do is give the, what we're doing today, this is the first time we're hearing this. We're determining the facts of the case and jurisdiction. We will not be making a decision today other than to determine whether this falls under the auspices of the Sunshine Ordinance. We'd like to give the petitioner 5 minutes to present, and then we'll hear from the respondent, and then we'll proceed from there. So, Ms. Leger, when you're ready with the timer, please let the petitioner know that they can begin speaking.
And to clarify, are we talking just on jurisdiction or on merits in this 5-minute presentation?
Oh, everything. We will determine whether there is jurisdiction, so you should present your case to us.
Okay, thank you.
In addition, we'll be determining if the records are public and to forward to the task force. So those are two other
Correct.
issues the committee will be dealing with. Okay. Are you ready, sir?
Yes.
Go ahead.
All right. So the issues in this case are requests for an audio recording of a call to police dispatch and a computer-aided dispatch record. And these both relate to an incident that happened at our residence in February 2020, resulting from a phone call from an out-of-state medical clinic. Our evaluation of the legal claims associated with this incident and the people involved have evolved since we submitted the Sunshine Ordinance Task Force complaint in November. So I do want to expand just a little bit on what we've written already. So our original focus in the November complaint was on learning the name of the reporting party. We now know from police body camera video that was disclosed to us a year after we requested it, we know who the reporting party was. At least the first name was mentioned in the video, and that's enough for us to know who the person is. So although we think that information should be disclosed, our main focus now is to find out exactly what the reporting party said to the dispatcher and what that conversation was. Was she asked for information, or did she provide it voluntarily? Because this information will affect our potential claims against the person. Welfare and Institutions Code Section 5150E creates a private cause of action for anyone who provides false information that can result in a person being taken into custody pursuant to that statute. So our position is that statute implies that a person can find out the name of a person who placed such a call to police, because that it would be one way the person could take legal action against that reporting party. Our position, furthermore, is that the reporting party does not have a privacy interest in her identity in making such a report. If she does have a privacy interest, we believe Section 67.24 it makes it clear on the balancing that there should be that the interest in public disclosure outweigh privacy interests, because we do plan to take both legal action against this person as well as file complaints with licensing boards, and also we think the California Confidentiality of Medical Information Act is implicated. So there's a variety of administrative complaint processes that we want to proceed, and so we think that there's plenty of value in the orderly resolution of disputes for us to go through these processes, but we need the name of a person in order to do that. And so furthermore, the information about exactly what was said in the conversation will help us in pleading a civil complaint. So we also want to note that there's inconsistency in the city's position. The recording is redacted, and the audio recording is redacted in certain places, and some of the information that's redacted appears in the computer-aided dispatch report that we already received. So it can't possibly be true that information is confidential in one place but not the other. And some of the information that we most want from the audio recording is already disclosed in the computer-aided dispatch report. Also, we heard the assertion, I believe, from the city attorney's office in our appeal that there's private health information that's being withheld. And we think it makes no sense that the person requesting the information can't get the information about herself. And if for some reason that notion is a problem, then she should be able to waive her privacy right in order to obtain information about herself. So essentially, there are two categories of information at issue. One is the identity of the reporting party, and the other is information about the petitioner. And we don't think there should be much question that the petitioner should be able to get information about herself. Just a couple of minor points as I close. There's a note in the record at page 556 saying that the complainant called the I don't know, the COR office several times and advised she was upset to receive a redacted record, repeatedly asked for phone audio. We never placed any phone calls, so we have no idea what that's referring to. And finally, there are some pages in the latter part of this record, starting at about page 571, that don't seem to be related to our request, our petition at all. So I would suggest that those should be stricken. Thank you for your time.
Thank you. Is the respondent ready to present?
Yes.
Okay. Ms. Leger, if you could tell us when you're ready with the timer.
Can I ask the name of the respondent, please?
My apologies. My name is Kirsten Walker. I'm custodian of records at the San Francisco Department of Emergency Management.
You ready, ma'am?
Yes, ma'am.
Go ahead.
So to respond to some of the points that were made by the complainant, the audio that he is referring to, all the recordings were complete, save for the name of the reporting party. That was all released in the audio that was requested. That audio was provided in the request dated July 7th, 2020. And in regards to the privacy standard, we initially denied the request under our standard privacy policy. The complainant indicated that they believe that the records did not fall under that policy. We again consulted with the city attorney's office regarding this. They determined that the standard policy that we followed was accurate, and denying the complete request, including the responding or the reporting party's full name. Let's see, and in regards to the missing audio, there is information in this CAD that is redacted in the CAD printout and in the audio. Excuse me, it's not in the audio because the redactions were not made, or excuse me, the entries were not made via radio console or phone call. They were done on a terminal inside of a patrol car, therefore there would be no radio or telephone audio associated with them. So there are items in this CAD that were redacted that are not available in the audio because there is no audio format. The only other redactions made in this request were the name and phone number of the reporting party. And in regards to the release of health information, the requester's health information was released after she provided our office with a completed and signed HIPAA release. Again, that is standard practice. The policies and procedures of this department have been repeatedly vetted and upheld by the city attorney's office. We apply the same minimum privacy standard to every CPRA request that we receive. We believe that we were in compliance with the law, and we still believe we are in compliance with the law.
Would it be possible to respond just briefly to a factual
I'm going to say,
point?
Hold
I'm
on,
sorry.
hold on.
Go ahead.
Yes.
Okay.
So thank you, Ms. Walker, for that. I first want to ask the committee members if they have questions for either the petitioner or respondent. I see Member Wong nodding. Yes, please go ahead, Member Wong.
Yeah, I have a question for Ms. Walker. So something you mentioned, you said there's a standard privacy policy. Can you talk a little bit more about what policy you're referring to?
It's the California Public Records Act, specifically Government Code 6254. And again, we also reference San Francisco Administrative Code 67.24D2 in a majority of our privacy responses.
Thank you.
Member Neighbors, did you have a question? Please go ahead.
Thank you. I have a question for the petitioner. Ms. Walker mentioned that they received once they received a signed HIPAA request, they released your personal records back to you, and I'm wondering, are there still outstanding records? Did you receive a partial release after submitting your HIPAA request, or can you tell us a little bit more about that, please?
Sure. With all due respect to the respondent, the audio recording that we received is redacted because there are blanks. First of all, there are blank spots in it where it's obvious that people were talking and there's no audio. And second, if you follow along with the timestamps on the audio recording and the timestamps on the CAD report, it's obvious that they were talking during that time period. And there's information that's in the CAD report that could not possibly have come from another source except the phone call, because if you look at the timestamps on the CAD report, the police didn't even arrive at our residence until page 2, and there's all this information about nature of treatment that's on page 1, as well as other information that we heard the police talking about on body camera video that's not on the audio recording and it's not on the CAD report, and there's a big redaction section there. So if the position of the Department of Emergency Management is that it released a full audio recording, then it sounds like we should just get that unredacted audio recording, except for perhaps the name of the reporting party, and we would probably be done with most of this complaint. But back to your question about the HIPAA information, I would say that just guessing the CAD report probably has most HIPAA related, but not all of it, because there's information that the police were talking about amongst themselves about my wife, and that is not in either of these records. But I think there's more redaction in the phone call that we received than in the CAD report.
So am I allowed to respond to him, just for some clarification?
Sure, we'll allow it. We'd like to have the information.
Thank you. So I just want to confirm that we're talking about the same thing here. So in the CAD record that we provided, it has some redactions, and that's the name and phone number of the reporting party. Are you looking at a version that has more redactions than that? Okay, let me try that again. Yeah. So at 15:40:57 on the timestamp on the far left column, mm-hmm. There are redactions there. Are those the redactions that you're referring to, or are you looking at a copy with more redactions? Because between the name and phone number, which is the very beginning of the CAD, and 1540, the copy that I have that we returned to you does not have any further redactions in that chunk right there where they're talking about some of the medical conditions.
I'd like to ask: is this in our file that we have with the task force? And if so, can you tell us what page you're looking at?
Yeah, hang on, let me open it up really quick.
Page 541, I think, if I may jump in, is the one that I'm looking at that I think we're talking about. P541.
Sorry, I had it open and.
That's okay.
We're scrolling there. Let us catch up with you.
Let me know when everyone's there, and I'll just comment on what I see.
Yeah, so page 541, right? That's the record that we submitted. So
okay.
The time at 15:33, which is the far left corner of this CAD printout, there's a name, which is the name of the reporting party that was redacted, and then there's a phone number of the reporting party that was also redacted. There are no further redactions until 15:40:57, and that was a law enforcement database inquiry made from a terminal inside of the patrol car of the responding unit. There is no audio file associated with that.
Ms. Walker, can you tell us what is that redaction for?
It's because they've either ran a license plate through a law enforcement database or a name in a law enforcement database record search, basically.
Okay. Thank you for answering that question. Just among the members, it would seem that at minimum we would need some. Well, we're taking this in. I think there's some questions about when there are redactions. There needs to be an annotation as to why that what is being redacted. So what you just explained to us should have been included as this is redacted because it was this kind of information.
Right, and there is a letter that is associated with the request hold on, I'm trying to find it here. That was included. It looks like it's page 540.
Mm-hmm.
Yeah, we didn't argue this point because there was never any indication that that was the reason for disclosure.
Okay. So
unless
it's somebody else's privacy that is
just as a matter of course. It's okay. That's okay. This is thank you. This is helpful. So and forgive me, petitioner. I see your wife's name. Could you tell us your name again?
Douglas Carlson.
Douglas Carlson. Okay, Mr. Carlson. So at this point, you are seeking the first redactions, or you are seeking the information in you are seeking the redacted information.
That's right. I mean, if the reporting party's name today were the only issue, we probably wouldn't be here because, we have figured it out. We still think it should be released under the law. We don't think any of these other redactions in the CAD report are valid. And then definitely the audio, a good part of the audio that led to this CAD report is redacted. And if that's by mistake, that it sounds like that probably could be resolved fairly quickly, if the department's position is that they released it.
Okay, thank you both for answering our questions. Members, do you want to discuss this, or does anyone have a motion on this? It would seem that we do have jurisdiction here, and that this is the kind of case that the task force would consider. Does anyone have any other questions, or would you'd like to make a motion, and then we could take public comment?
I move that we refer this case to the full task force for consideration. Can we make also a recommendation to, or
we don't make recommendations. What we do is we should find jurisdiction and refer to the full task force. We can, when we are in front of the full task force, we can make a presentation, and I can invite you to make comments about this if there are things that you want to share with the full task force.
No, I was actually just going to encourage it sounded like there was perhaps some movement between the complainant and the petitioner. Encourage them to determine if things had changed before that time. If they were able to rectify this without needing to go to hearing, or if they are, then that we would be open to that as well. So.
Thank you. That's a good point to share. And as is always the case, we are here to represent members of the public, but if they're able to resolve things on their own, we encourage that because it gives us more time to deal with other cases.
I'm happy to work with Mr. Douglas, but it is our contention that the audio record that we released, as far as I know, was complete with there were no HIPAA redactions to the audio files that we provided. The only audio file that we provided was redacted with the reporting party's name and phone number.
I'm sorry, can I step in. I think, Doug, you should just read them what is being redacted and tell exactly the time codes, because I'm not sure that, we understand each other.
Well, I think on the, for instance, at 1536, there's a discussion of the nature of treatment that's in the CAD, and that's redacted from the phone call. I mean, a substantial portion of the phone call is redacted, unless
not only the name and
not only the name. I mean, it's to say it's a partial conversation would be an understatement.
So here's what I'm going to
that's just a mistake. Yeah.
It sounds like and Ms. Walker, I would invite you, if you think that there is perhaps a misunderstand or a way to clarify this, between the parties, we would encourage you to do that. At this point, there is a complaint. I think we're going to find jurisdiction, and I should not predict what we're going to do, but it seems that it seems that we're going to find jurisdiction, and that this is within the scope of the task force duties. So. That said, if you think that you're able to resolve this, if you confer and are able to reconcile those two files, please don't let our decision today stop that process. If you think there's an opportunity there.
We would be happy.
In the meantime.
Sorry.
Sorry. Go ahead.
I was going to say we would be happy to provide the complainant with an additional copy of the audio records that we believe we provided initially, because again, it was never our intention to redact any medical information from this CAD. The only redaction, once we got the HIPAA release, there was no reason for us to do that. So the only redactions that we made in the audio, again, was the name and phone number of the reporting party. So we would be happy to release another copy to them to see if that satisfies their needs.
Well, my suggestion, I appreciate the offer. My suggestion would be to release a copy that's not redacted, except for the complaint, the reporting party, because there's no point in releasing an identical copy of what you released already. Well, but I think we have a meeting of the minds about what's the outcome is going to be, and it sounds very productive.
Right. Well, it sounds like we're confused because we believe that you're referring to more audio redactions than we did. So that's why I just want to clarify. We would be happy to redo the record, submit another copy to you to see if that satisfies your needs.
Yes.
But that would be still with the redacted name and phone number of the reporting party.
That's right. But I think that's progress, if that's
if the only name and the phone will be redacted, but not the other information that the reporting party was saying, because other information was redacted.
Okay.
And this is the copy what we have.
Okay, I'm gonna make a recommendation here, and we actually, you know what? I'm gonna make a motion, and I would like to make a motion on this because it seems that there's some movement on this case. I'd like to make a motion that we continue this because I'd like to hear back from the parties about whether, actually, you know what? Can I do that if we haven't determined jurisdiction yet?
We haven't had a motion.
Jurisdiction, but then you can continue it after you find jurisdiction.
Okay, I would like to make a motion to. And does that have to be two separate? Do we have to vote on the jurisdiction motion first and then make another motion?
I think I have to withdraw. Since I already made a motion, I may have to withdraw my motion for you to make a motion. Don't I?
Motion?
You can amend the motion. You can move to amend the motion.
I made a motion that we find jurisdiction and move to but then I went down we just talked to each other.
Right. Okay, member neighbors, let's have you withdraw your motion and make a new motion.
I'd like to withdraw my motion, please, Chair LaHood.
Yes, motion withdrawn.
Thank you.
Would you like to make a new motion?
What's the last word again?
Didn't you have an emotion that you were interested in making?
Okay, I would like to make a motion that we find jurisdiction in this case. Do we have a second?
I second. Yeah.
Okay, we're going to open this up for public comment. This is purely for determining jurisdiction. Is there any members of the public not involved with this case who would like to make public comment?
Sure, Luja, would you like to combine your motion of finding jurisdiction and continuing?
I would like to, if that is allowed. So
that is allowed.
Okay, second, the addendum to this motion is I am making a motion to find jurisdiction, and then I would like to continue the matter to give the petitioner and the respondent an opportunity to see if they might be able to agree on what public records should be delivered, and if they could report that back to us, and then we can determine whether this should be moved on to the full task force or if it can be resolved at this stage.
So we're moving to, if we're continuing, then we'll say next month in June, we will have this matter. We will find out if records have been exchanged.
Yes, so we need the petitioner and the respondent to, we need the petitioner to let us know what additional records have been received and if they are whether they are satisfactory.
Do we want to give a certain number of days to them to do that, or do you want to wait until next month to have another hearing? Should we say is 2 weeks enough time, 14 days?
Let me ask the respondent, do you think this is something that can be resolved in 2 weeks?
Oh, yes, definitely.
Okay, let's give it a 2-week deadline.
Okay.
Okay, so that is my amendment. Member neighbors, do you accept the amendment?
I do.
Okay.
Okay. Member neighbors, are you seconding?
I am. I'm seconding.
Okay.
So now we're going to public comment.
Yes. So we would like to open this up for public comment. This is for members of the public who are not party to this case. We'll take a cue. If you need to please unmute yourself by pressing *6. When you're not speaking, please mute yourself again, also by pressing *6. Is there anyone who would like to make public comment on this motion?
Anonymous, please.
Okay, I heard anonymous first. Is there anyone else? We'll create a queue. Okay, I'm not hearing anyone else. I will ask once again after Anonymous speaks, if you could wait until Ms. Leger tells you that she's ready with the timer, and then we will take your public comment.
Are you ready, sir? Wait a second.
Yes, I am.
We have background noise. Whoever's not speaking, please mute yourself. Thank you. Anonymous, are you ready? Anonymous?
Yes, I am.
Okay. Go ahead, sir.
Thank you very much. First, I wanted to thank the chair for doing the double check on public comments, both taking a queue, then doing the actual whoever's in the queue, and then checking again. I hope that's done at all the other committees in the full task force as well. It seems like this is somewhat different than what you often do when it's possible that there might be a resolution. And if the complainant is happy with this, that's great. That's fantastic. That's the goal. The reason I suggest, normally I thought that you say, well, you're finding the records are public, you're finding jurisdiction, and you're sending it to the full task force. It sets a forcing function, a deadline for the government to do whatever they are promising to do at this committee meeting. Otherwise, let's say DEM says something to the complainant right now, they're agreeing to doing something, but then they do something slightly different, or they don't do what they say they're going to do, or they don't do it fast enough. That person kind of has the ability to hold that final hearing over the government. And so the person might actually be able to get what they want faster. Now, maybe the complainant doesn't want any of that. Maybe they believe they're going to get exactly what DEM says they're going to give, but they can always withdraw a complaint even after you send it to the full task force, which I assume is why the complaint committee, for example, usually does that. It sends it to the full task force and tells the government, the agency, the respondent, well, you have X weeks, do it within that time, and maybe the complainant will withdraw their complaint. Thank you.
Thank you for your comments. Is there anyone else who would like to make public comment on this motion?
Yes, please.
Okay, Ms. Leger will tell you when she's ready with the timer.
Go ahead, Mr. Warfield.
Thank you. This is Peter Warfield, Executive Director of Library Users Association, Library Users 2004 at yahoo.com, and P.O. Box 170544, San Francisco, California 94117 -0544. We're not a party to this. We're not familiar with it, but I have to say that with a fair amount of experience with the task force over many years, it's my impression that pretty much what Anonymous said is correct. This matter, if you send it to the full task force, cannot be heard in the June meeting. There's really not enough time to get the pieces together. The earliest it would be heard is in July. And if, in fact, the satisfaction of the complainant can be reached within 2 weeks, that should be plenty of time for the complainant to say, you know what, either I want to go forward with this or I don't, for whatever reasons. But I think that as Anonymous said, the pressure of having a hearing and having an adjudication at a presumably independent body is very important and very valuable in getting movement on these cases. And when you ease off on the pressure and lengthen the already at times exhausting length of time that it takes to get to these places, you undercut justice, you undercut timeliness, you undercut the complainants and the public. So I'm glad that there is movement. Excuse me, and I'd also second what the Anonymous said about taking public comment scrupulously, and in my opinion, scrupulously, during today's meeting. But with respect to easing off on the pressure, I think the opposite is the best procedure. And the Sunshine Task Force would have no problem if there were a withdrawal to substitute something else if it were to come in 2 weeks or even a little longer. And who knows when they're actually planning to
30 seconds.
put this on the agenda anyway, since there's quite a backlog already. So I do think that at the very least, there should be a request from the task force to the complainant as to what the complainant thinks. But in any case, I think that generally speaking, it's a good idea to move forward with promptness, and I think that would improve the process. Thank you very much.
Thank you for your comments. Is there anyone else who would like to make public comment on the motion currently on the table? Okay, hearing none. Members, what do you think? Is there enough pressure to get this resolved with our current motion, or should we, I listen to what people say in their public comment, and there were some interesting points. I think from if the petitioner and respondent are able to resolve things as it seems that they are given their exchange today, that it wouldn't matter one way or the other. However, I do hear what people are saying, even though there may be good intentions on both sides. If there's not resolution, would we be slowing things down by proceeding in this manner? What do you think?
This is Member Wong. I feel like the 2-week mark is a pretty good amount of time because, yeah, as I think Mr. Warfield mentioned, it's likely that we would not be able to agendize this for the June meeting and it would have to wait until July anyways. So I don't feel like we would be slowing things down, but I think either solution would work well, because I think either way, if things are not resolved, it will get moved to the full task force based solely on the fact that we have found jurisdiction.
Yeah, I don't have strong feelings either way, and if you're if you're wanting to retract that and just go ahead and send it as per public opinion or public comment, happy to do that as well.
I'm thinking about this because based on the conversations today, I think we might be okay with where we are. But you know what? I'm actually going to ask the petitioner. Petitioner, do you have strong feelings about this? Would you be satisfied with our current motion, or would you prefer that we refer this to the full task force, even knowing procedurally, even if we refer it to the full task force, we would also ask to receive the same information within 2 weeks in hopes of resolving this before the next hearing regardless?
I would suggest that we move forward in the interest of time, because in our appeal to the city attorney on July 15, 2020, we made it very clear which kind of information was withheld from the audio recording that we thought was improper, and why nobody bothered to figure that out until now is relatively disturbing. And so I appreciate the public comments and saying why are we imposing delay. It seems like in reality, if there's going to be a resolution, it should be known within a week. And Ms. Walker and I can take that offline, but I think it's not going to be very difficult to figure out where we go with this. So why inject a procedural delay would be my suggestion. So maybe it should just move forward to the task force, and still we hope that we resolve it and let you know.
Okay, I am going to rescind my motion and make a new motion that we find jurisdiction and refer this to the full task force. And I would also like to combine it with a motion to request that the respondent, since the respondent has offered to try to resolve this and provide the information to the petitioner within 2 weeks, that efforts are made to do that, in which case we will hear from the petitioner as to whether as to whether we should proceed or whether the complaint will be withdrawn.
If I may, it's still our contention that we did not provide that type of audio recording. We are completing a new copy from scratch, as we believe we had, but we are presenting a new copy. It will be out in the mail tomorrow to the requester.
Okay. This sounds good. It sounds like in terms of what the two parties are going to do within the next 2 weeks, this wouldn't change anything. This would just mean that if for some reason there's a breakdown in that process, that this committee would not be slowing things down in terms of referral to the full task force. So so I have made my new motion. Would someone like to second the new motion?
I'll second your motion.
Okay. I'm going to open this up for public comment again, but seeing as we've spent some time on this already, if our Ms. Leger?
Yeah. I want to be clear about what this motion is before we go any further. You are moving to refer to the full task force with the request that because the respondent has offered to provide the information.
Administrator Leger, let me clarify. I believe to simplify it, the motion is to find that the task force has jurisdiction and refer to the full board, to the full task force without any recommendations. And then in addition to that, it's not really part of the motion, but it's just advice or a request that the parties work together to get a new copy of the audio to the complainant. And if the complainant agrees that that satisfies his records request, he can always contact us and withdraw his complaint. But in essence, the motion is a very simplistic one. We are finding jurisdiction and referring it to the task force. And they're going to do some work between now and then to try to resolve their problem.
Right.
Chair LaHood, if I'm
Yes.
mistaken, please let me know.
All right,
No, that is what we intended. We are finding jurisdiction. The records are public. We are making this additional suggestion. And now that we have a motion and a second, I would like to open this up for public comment. Do any members of the public who are not party to this case, would anyone like to make comment on this new motion?
Yes, please.
Okay, I heard the first person. Is there anyone else who would like to get in line to make public comment? Okay, I will ask again. I'm the first speaker. Ms. Leger will let you know when she's ready with the timer, and then you may give your public comment.
Are you ready, sir?
Yes.
Go ahead.
Thank you. This is Peter Warfield, Executive Director, Library Users Association, Library Users 2004 at yahoo.com, and P.O. Box 170544, San Francisco, California, 94117-0544. First of all, I would like to thank Cheryl Leger for asking for a clarification. I was afraid I'd have to ask. I think it's always good to be crystal clear about what a motion is, what it says, and so on. So thank you for that. I'd also like to thank Victor Young for basically simplifying and clarifying what that ultimately was. So yes, certainly as someone not participating, but somebody who's had a lot of experience, in my view, this is the right motion to make. There's also the question of whether for some reason or another, there might want to be from the complainant a record. And so even when something comes through that one wants, whether it's not the fully desired thing, or whether there are some changes that happened that were not so satisfactory, or whether it's just a matter of having taken longer than allowed or required by law, the complainant might still want to go to the full task force and get an order of determination and basically a determination of a violation, even if ultimately the stuff does come through. Timeliness is certainly important, and what they say, justice delayed is justice denied. So thank you very much, and certainly we would support this motion.
Thank you for your comments. Are there any other members of the public who would like to make comment on the new motion?
Yes, please.
Okay, Ms. Leger will let you know when she's ready with the timer.
Someone needs to mute their phone.
I think it's the speaker who's about to speak.
Okay, you ready, sir?
Yes, I am.
Go ahead.
Thank you. I would simply say I agree with everything Mr. Warfield just said in his previous comment. Thank you.
Thank you for your comment. Is there anyone else wishing to make public comment on this motion? Hearing none, let's call the vote.
The Compliance and Amendments Committee moves to find that the task force has jurisdiction to forward, that there is jurisdiction to forward the matter to the task force with the request that the parties work together to provide the audio and this is where I'm not clear. What exactly are we providing here?
We're providing a new copy. We basically started the report all over again. So we have created a new copy that we believe is what satisfies the requester's request, and we are shipping it off in the mail tomorrow.
New copy of the audio?
New copy of the audio. We created a whole new file, started from scratch, like this is day one. And so it's a new copy of the audio that we have reproduced, or that we have reproduced for this request.
And the committee has requested that happen within 2 weeks, and it sounds like that is in motion.
Yeah. So let me just make sure I got it right. Move to find that that there is jurisdiction to forward the matter to the task force. The records are public, with the request that the parties work together and the respondent provide the audio, provide a new copy of the audio within 2 weeks of today's hearing, and we should hear back on that. I should hear back on that. I should get an email. I would like an email from both of you saying that the exchange has actually taken place. I have to put that in the record. Okay, can I get you guys to agree to that?
Maker of the motion, I am satisfied.
All right, good.
Yes, petitioners will respond within, did we say 2 weeks?
14
as soon
weeks,
as we
yes.
know. As soon as we know.
And we are responding with our new records within 2 weeks.
Thank you so much. Okay. Chair LaHood.
Aye.
Chair LaHood, aye. Member Neighbors.
Aye.
Member Neighbors, aye. Member Wong.
Aye.
Member Wong, the motion passes.
Thank you, everyone. We appreciate your participation. We appreciate the public comment, and we appreciate the willingness of the parties to work together on this matter. Let's call the next item, please.
Item number 6, file number 20079, complaint filed by Shane Anderes against the District Attorney's Office and Chesa Boudin for allegedly violating Administrative Code Section 6721E by failing to respond to a records request in a timely and or complete manner. 6725 by failing to respond to an immediate disclosure request in a timely and or complete manner. 6726 withholding kept to a minimum. And 6727 failing to provide justification for withholding of responsive records. So,
thank you. Is the petitioner here?
Chair LaHood?
Yes.
This is Victor Young.
Mm-hmm.
I just wanted to clarify the purpose of this matter was being referred to the committee as listed in the notes. The task force requested that the district attorney's office representative verify whether the signal search was done when originally requested, and if new search returns responsive messages, and that they be turned over. So we're just doing a follow-up on the full task force hearing,
right,
to see if the district attorney has conducted the signal search.
Yes.
I got an email from the district attorney's office saying that they had completed the signal search.
Okay. And was that provided to Mr. Andres?
I don't know off the top of my head. I can certainly look.
Okay. So in other words, the search was done, that was communicated to you. Is it our understanding that neither party is at this hearing?
That was not my understanding. Oh, go ahead. I'm sorry.
Hi, I'm sorry. This is Robin Burke from the District Attorney's Office, and I confirmed that we sent the email to both the task force and to Mr. Andres.
Okay, thank you for doing that. Thank you for confirming. So it sounds like at this point our request there was compliance with our request. I guess members at this point, should we have a motion then to refer this back to the full task force? Okay, who wants to make, I'm going to give you an opportunity. Who would like to make this motion?
This is Member Wong. I'll make a motion to move this back to the full task force.
And do we have a second?
This is Member Neighbors, and I will second.
Okay. Victor, it looked like you might be trying to say something, and I'm
No,
sorry.
I was just saying that everyone was muted, and we weren't hearing you. But I would also maybe suggest acknowledging that the department has complied with the request of the task force.
Yes. So could we ask Member Wong to amend her motion to include that the recognition that the department complied with the request of the task force?
Hello, this is Petitioner Shane Andrews, and it wasn't until someone just indicated that we were all on mute that I didn't realize you didn't hear me check in when you asked if I was present.
Well, thank you. We thought you weren't here. Welcome.
No, I was talking to myself, and I just wanted to, I just wanted to follow up first to confirm, yes, that I was copied on Ms. Burke's email to the task force indicating they had done the search. But I wanted to add, I had also responded to her email, also to the rest of the committee, because my concern / request was that while she confirmed they did the signal search, I think that another request from the committee was, first of all, to confirm that the search was also done when the request was initially received, not just obviously a lengthy time later after the last hearing. And I don't think that was addressed. And then the broader concern of mine.
I did address that. I made it clear that it was confirmed, it was done at the time that the request was received.
Oh, okay. And you know what? Fair enough. I'm just pulling up the email now in front of me, and that you're right. That is my mistake. It says that the original search included Signal when we initially searched for responsive records in February 2020. Okay, so that is correct. The broader, as I was starting to say, the broader concern was that the DA search was only for Mr. Boudin's account. And the public records request is not just to Mr. Boudin individually. In fact, it's to the district attorney's office. And Ms. Burke did confirm that they only looked at Mr. Boudin's account, not any of the other devices we asked to be searched, not only of Mr. Boudin, but of any other district attorney employee that would have been responsive, because the request was brief, but indicated we wanted all communications to or from Mr. Boudin. And just because he may have deleted information at a certain period of time, like email, doesn't mean that another party who sent it to him or received something from him also deleted it. And so none of that information was searched. It is now stale. And the concern is that, we may never be able to have access to it now. And that's also despite a preservation letter. In other words, a letter I sent to them back in January of 2020 indicating that Mr. Osley might have claims against the office and therefore needed to be preserving everything. So I guess I'll just stop there. But the point is that while, yes, Ms. Burke did confirm that the original search included the Signal app, that was it, right? And I think it revealed the larger problem, which is it only looked at Mr. Boudin's account. And I also don't know what devices or other apps may have been searched. Signal only came up at my suggestion during the last hearing because my client happens to be aware that there was such communication. So the problem there is it's like, having to address these issues on a Band-Aid level basis, right? Like, what if I come on here today and I say, well, what about Outlook Messenger app? Do we have to now go back and confirm that that was searched? Or some other app? The point being is that the ordinance requires that they respond and withhold as little as possible and, explain that they're complying rather than having to show up at hearing after hearing and doing it piecemeal. So that's my concern. And I'm not. I said in my follow-up email what I wanted the committee to do, which was to find a violation under the various sections I cited originally, because, again, what's clear is that there was not a thorough search done. back when this was requested more than a year ago, and now it's very possible that any responsive information has since been deleted or destroyed.
Mr. Andrews, thank you for your comments. I do want to ask the respondent, and I appreciate that that there was follow-up on this request. We won't be making a decision on the merits of the case. We will be referring things back to the full task force. But I wanted to give the respondent a chance to reply. Were you, we appreciate you verifying what was done in the past and then doing the new search. Did you search beyond Chesa Boudin's account, or was it just his account? And did you look at other apps or just Signal, which I believe is what we had requested?
Yeah, so when the request first came in, if you just give me 1 second, I apologize. I had it up on my computer and then it disappeared. When the request first came in, it was for any and all communications sent to or from Chesa Boudin regarding Thomas Ostley during such a time of January 1st, 2019 to February 4th, 2020. And so we did a search of the district attorney's email accounts and his cell phones and all of his messaging apps at that time. Mr. Andrews is also referring to a letter that came to us earlier on January 17th, 2020, a preservation of evidence letter, and that was received and all evidence was preserved. And we provided all of the records that we found at that time, and we believe that we complied with the request.
Okay, thank you. Committee members, do you have questions for either the petitioner or the respondent at this point, or anything that you would like to recommend regarding what to do next? Okay, I would like to make a motion that we accept what was provided in the new search and report back to the full task force that there was compliance with our request, so that the full task force can then proceed with. And I'm hearing somebody who needs to mute. If there's somebody who is not me speaking, needs to put themselves on mute, please press *6. Thank you. So I would like to recommend that we accept the information and the response to our initial request, refer it back to the full task force so that the task force may proceed with this hearing. And Mr. Andrews, I know you have additional concerns about this, which I believe you will have opportunity to discuss with the full task force when this case is then heard at our next full task force hearing. That is my motion.
Thank you.
Yes.
Thank you, Chairperson.
Can I add one thing?
Okay, I'm going to give you each a chance to speak. I heard Mr. Andrews.
Sure.
Please go ahead.
Sure, no, go ahead, Ms. Bird.
Okay.
Oh, I was just going to say, additionally, Mr. Andrews pointed out that there was one email that was subsequently turned over in a secondary search, or in a secondary request, and and then in a follow-up email after our last task force meeting, he found one more, and because of those two emails, I asked our IT department to do a sweep from the back end of all of the district attorney emails for Mr. Ostley, anything having to do with Mr. Ostley that we might have missed, and I found the email or the correspondence from Mr. Andrews' law firm and one other record. And so I'm going to be sending that to all of you right now. And okay. And so there is one additional record that I'll be turning over as part of this request.
Okay, thank you for that. And Ms. Leger, if we could make sure that these new documents are then added to the record for the case, I think that will be beneficial to everyone. And Mr. Andrews, was there something else you wanted to say, or was it referring to those additional documents?
No. What I wanted to add, and it was sort of right before you were about to make your motion, and I think it's relevant. I understand I'll have an opportunity in front of the full committee to make the same points I already did. However, with respect to just this particular issue in motion, I think that there cannot be a well, let me rephrase. The district attorney did not comply with the request to go back and search the Signal app because it only did it for Mr. Boudin's account. And Ms. Burke did acknowledge that, I had sent this preservation letter. She states that everything was preserved. And so if, in fact, the district attorney was to do what this committee had asked and search Signal, it's not just a matter of Mr. Boudin's personal Signal account. And the fact that the district attorney initially, through the IT person, conducted a broader search, right, for any reference to Mr. Ostley, or at least I thought that's what I heard Ms. Burke say, which is surprising. I would have expected there to have been more. But again, if we want to stick just to this particular task force request about searching the Signal app, I don't think it has been complied with because it didn't. The district attorney did not search its Signal app accounts, plural, for its employees. It selectively asked Mr. Boudin for his, and Signal being an app that, deletes automatically, that is not helpful when Mr. Boudin has at least the incentive or motive to get rid of any responsive information since he's already been notified that he's a potential party in a lawsuit. So you can see the problem I have with this is that it's not in fact complying with the task.
Hold on. We're not going to have crosstalk. Mr. Andrews, I'm going to have you pause, and I want to ask Ms. Burke, did you search Signal apps beyond Mr. Boudin's account?
We searched all correspondence to and from Chesa Boudin on his account.
On his account. Did you attempt to search accounts of others who were part of the original document request?
The original document request requested all communication to and from Chesa Boudin.
Okay.
That is all it requested.
Okay. Did you search Signal accounts from individuals within the department who may have sent him Signal messages?
I asked the district attorney to search his phone for any messages regarding Thomas Ostley, and he did so and did not come up with any.
Okay. I want to ask my fellow committee members, I understand what Mr. Andrews is saying, that since he wanted correspondence between Chesa Boudin and others in the department, and if only his Signal account was checked, it's possible that if he deleted messages that they might exist in the Signal accounts of others. What are committee members, what are your thoughts on this? And does this mean that the request was not complied with, or that we need to send it back for further investigation? Or was our request, as it was worded, was there sufficient compliance that you think that we should send this back to the full task force?
This is Member Wong. I think this one is a little bit complicated when I'm looking at the original complaint. And it looks like what was requested was all communications to and from Chesa Boudin regarding Thomas Ostley. I guess I don't know, would that require the department to look at everyone within the district attorney's office, search those Signal records then? I guess it's a question.
Yeah, I mean, this is a little bit complicated because, it's we know that Signal can be set to have messages disappear automatically. We don't know how it was set at that time, so it's in that sense we don't know. Is it possible that there are messages that may have been deleted from his account for which there would still be records in other accounts? In theory, yes. The question is, at this point, do we, since the petitioner has made this request, do we defer to the petitioner and say this needs to be continued so that an additional search can be done on the Signal accounts of everyone else in the department to see if there are other messages to or from Chesa Boudin in their Signal accounts? Let me ask Mr. Andrews, is that what you are asking us to do?
It is what I'm asking. I think you did a good job of summarizing it. And my question would be, why would they have done it as to all emails? What's the difference? In other words, to answer one of the other questions that came up, indicating, maybe this is different, right? But it's not, because the request is to the district attorney's office, not to Mr. Boudin. And the district attorney understood the request sufficiently to understand that you would search the email server, which would have included, emails coming from other accounts.
If I can interject, that's incorrect. I searched emails to and from Chesa Boudin, from his account, from the district attorney account, arguably the public district attorney account that you could say is to or from Chesa Boudin, as well as his phones. And
so that's okay. Then it is. Then it is a much larger problem.
Subsequently, your second request that you submitted was a much larger request for all emails within the office, and that is the information that we've provided to you in your secondary records request.
Right, and that I believe is the subject, or maybe the subject of a separate Sunshine complaint. It was a subsequent request, and it was sent because of the fact that we weren't getting information responsive to the first request, which is, again, it's a request to the district attorney's office for, and I won't repeat it. I think Chairperson LaHood, you explained the whole point was it's supposed to be internal communications of a department regarding a particular individual, right? And communications within that department to or from the head of that department. So if to say that all is required is to go to the head of that department, who again, in this case, in many other cases, may have an incentive or motive to get rid of that information. And not to forget, we're talking about an app designed to do just that. One of the questions that maybe the committee could ask Ms. Burke is, well, what were the settings on his account at the time you searched?
Okay,
or on any of the accounts.
So, Mr. Andrews, based on, since this is a hearing regarding your first request and not, and correct me if I'm wrong, but not the second request, which you worded more broadly, is that correct?
Yeah, but I don't want to be confused. That's a red herring. This request was written simply to avoid exactly the issue that happens when you ask for a whole bunch of requests, is that the respondent says, well, this is complicated. It's going to take a long time. It's confusing. It couldn't be more simple. It was communications to or from Mr. Boudin in the office. And that is a search beyond simply his device or account.
Okay.
I would be surprised if this is a new issue for anyone on the committee. And so,
Ms. Burke, let's talk for a minute. So, first of all, I appreciate the extra search that you did to comply with our request. In order to make sure that we have all the information we need before sending this back to the full task force, because it seems that if we send it back to the full task force, I can foresee a situation where Mr. Andrews said, but we still don't have everything yet, and then coming back full circle again to this committee. To avoid doing that, would you be?
I appreciate that.
Sorry?
I said I appreciate that.
Yeah. So to avoid doing two cycles when we can do one, what I'm thinking is, would you be able to go back and do the search that you did on Chesa Boudin's Signal account, repeat the search for messages to or from him on the Signal accounts for all members of the office. And now I'm going to go over to Mr. Andrews. Was that sufficiently done with the email, or you want to see this done with the email as well?
Yeah, I think it should have been done across all communications within the office.
Okay,
all
so
employee accounts, email, Signal, and any other if they can identify them. I don't want to have to, do the thing where I get a production of something from a different app. So now do I have to come back and make sure? That's why normally you just say, yes, here's what we searched. And I thought that's what the committee had asked. Can you come back and tell us exactly what you did?
So Ms. Burke, here's what I would ask is that if you could report back to us whether you have done searches across the department over email, Signal, and any other apps that people in the department use to communicate with each other. And if that means text, regular text messaging searches as well, if you can verify whether it has been done for all members of the department for messages to and from Chesa Boudin, or if it has not been done, if you could do it and let us know if there are any responsive messages. Is that something that you would be able to do?
I can look into it. Yes, of course. I can tell you that emails have definitely already been searched. Based on the subsequent request. And I will put out a request to members of our office about any messaging and messaging apps that may be used to communicate with the district attorney, and if they have any reference to Mr. Osley.
Okay. If we were to do that and say that is that something that you think you could do in 2 weeks? Or
yeah, I think we could do that.
Okay. If that's the case, just so we don't, again, have 2 cycles of this, members, would someone like to make a motion, or would you like me to do it? I'm happy either way.
I would like, if I could just say one thing,
sure.
That I'd like to point out that Mr. Andrews has now made reference to the district attorney deleting information after we received a retention request, and I take, I would like to just point out that is inaccurate, and it calls the district attorney's honesty into question, and I take offense at that.
You are welcome to put that on the record. I don't think the task force is not making any judgment. Yeah. All we are trying to do is, we have no judgment on this.
I appreciate that. It was said a number of times, and I feel like I need to speak to that.
You are welcome to respond to that. So
thank you.
Task force or committee members, does one of you want to make a motion on this, or would you like me to make a motion? Oh, you're letting me do it again. Okay, you get to do it next time. I would like to make a motion that we ask the district attorney's department, and we ask Ms. Burke is the representative, but we ask the district attorney's department to verify that a comprehensive search of department communication mechanisms, including email, Signal, and any other messaging apps, has been done to search for communications to and from Chesa Boudin with the regarding Thomas Osley, and that this search will be done, and we will get a report back to us and back to the petitioner, Mr. Andrews, within 2 weeks. And then once we have verification of this, we will take it up again as a committee. And once we have that information, we will be in a position to refer it back to the full task force. That's my motion. Ms. Leger, was that too long?
Yep. That was long. I was trying to type it. Okay. I just want to be clear. Hang on a second. You move that we ask the district attorney's office to verify that a comprehensive search of department communications has been done, and to specifically search for communications to and from Chesapeake regarding Thomas Ostley. Once the committee, okay, as part of
And I'd like to including, but not limited to, email, Signal, and any other messaging apps used within the department. And that this should be done within, this should be returned to this committee and Mr. Andrews within 2 weeks. And I see Member Neighbors has a hand raised.
Return to the committee next month in June. Is that what you mean?
I said, yeah, I said in 2 weeks. So then we could determine if this, if it's ready to be on the agenda for our next hearing.
Okay, so what you want them to do is like notify me? Then
Yes.
I send it to the committee members? Okay.
Yes.
We signal other messaging apps within the department to be forwarded and the results to be forwarded?
Yes.
To the SOTF administrator. To be reviewed at the next CAC hearing.
Yes. And Member Neighbors has a hand raised. I think she might have something to add.
Hang on. All right, guys. Okay. Is this part of the motion, Member Neighbors?
Yes. I'm wondering if, I guess I'm proposing an amendment, but I want to, if we could have a little discussion first. You know, one of the points that was made is that this information is only as good as there is disclosure about the settings of a Signal app. And I'm not a software engineer, wish we had one here. But I believe Member Wong is a software engineer. I had never heard of Signal until this case, so I'm obviously not a software engineer, but I'm wondering if there's something that we can include in this around understanding what the settings are, getting information back on what the settings are, because I think the petitioner is exactly right. The settings are what, my understanding is that the settings of individuals' phones, whether or not they're using Signal, it's imperative that we know that to really get any sense of whether or not those messages are being deleted on their end as well. Is that correct?
Member Wong, do you have a recommendation on that, or a way that this could be worded that is that could actually be applied?
Yeah, I think we could just request for the settings themselves, just to ask, because that would give us an indication of whether or not, you know, the records were retained. I think, at least in Signal groups, there are ways to retain most messages over a specific period of time. And I mean, you can also retain the messages just by, you know, keeping them or printing them out. So my recommendation would just be to request for the settings, though it's difficult because it's like the current settings and it may have been different at the time that the records were requested.
Right. It's kind of like if the door to my apartment is locked now, it tells you that it's locked now. It doesn't tell you whether it was locked last week. Yeah.
Perhaps this is something really important for the district attorney's office to take into consideration when they're using Signal for communication in the future. That by using an app that actually is designed to erase messages, they're setting themselves up to not be able to comply with our open records laws. I'm sure they don't want to do that.
Yeah. What one follow-up question for Member Wong? Are you suggesting that we would need to request verification of what the settings are on each person's installation of this app?
I guess that would be the case. I think this one is also complicated because it sort of depends on if they're using their personal devices for government business also, or if they have multiple devices. It's a whole nother question as well.
And if they are communicating on their personal devices about government business, that's still a public record.
It's still a public record. Mr. I don't know. I feel like we should just be asking this across the board. And Ms. Burke, I know we're asking for another layer of information. Would it be possible to, I guess, group into categories, or at least say everyone has the same settings and these are what the settings are, or these people have these settings and these people have these settings?
You know, this is assuming that everybody uses Signal. I think that
right.
If there are specific DA employees that Mr. Andrews would like me to ask, that would help narrow this down. I'm sure that he and Mr. Osley have specific people that he would like us to look into. But you know, I going across the 300 plus people who work on our office and asking them if they use Signal and if they used it at this time to communicate with the DA is not going to be useful, because, you know, at the time that the request came in, he was very new to the office and was not communicating with everybody in the office. It was certainly not via Signal or
Mr. Andrews,
text message.
Mr. Andrews, are you requesting the Signal settings for every person in the department, or for a specific list of people who you believe to have or do you want the Signal settings for anyone where communication about Mr. Osley appears?
For everyone, and that was what my original request said. And my original request did say for all communications on devices, public or private, telephones, smartphones, computers, laptops, etc. And if Ms. Burke just said, well, there's not going to be much, right, because he was new to the office, then it's not particularly burdensome to then request it from everybody. And then the other point is that, you know, I'm concerned again. This has happened before. The request is the request. The petitioner should not be required to, you know, narrow it, you know, until it's no longer the original request.
No, I'm just asking what you're requesting. So you would like.
Oh no, I'm responding to Ms. Burke's point about, well, maybe if we identify, you know, some people in particular, it would make the job easier. And my response is that's not our obligation. It should have already been done. That if in fact there won't be much, as she believes there won't, then there shouldn't be any objection to searching for everybody. And again, it's not just Signal. That was the last point I wanted to make. Again, it's the reason you go to all of the people in the department is you find out what apps everybody's using. And as someone else just asked, you know, why would a public agency be using a self-deleting Signal app anyway? I mean, particularly lawyers where there's evidence preservation obligations, even for lawyers with their clients when it comes to, you know, ethics commissions and the state bar. You're not supposed to be just auto-deleting, much less public records, right? Communications about public business. And so I don't know what those are to identify for Ms. Burke. And so it's the DA's responsibility to do that and to let us know so we don't have to keep coming back again and again in Band-Aid fashions to figure out what it is. Because again, but at this point, I'm not expecting much either because so much time has passed. And if we're talking about self-deleting apps, you know, there you go. But that's a problem.
Okay, I appreciate your response. I have questions now from Member Wong and Member Neighbors. Please go ahead.
This is Member Wong. So I don't actually have a question. I have a comment about Signal. So I think by default, Signal retains all messages. So
correct.
You can set for disappearing messages after a certain amount of time, but it's also per conversation. So I don't know if we specifically would want, the settings for any person who is communicating with the DA, because that would be specific to that particular conversation.
You are right. So we want the conversation settings on any signal conversations to which the DA was a party. That does narrow things down.
Got it.
Good catch. Okay, member neighbors.
I didn't actually mean to have my hands up, but I just did want to say as to member Wong.
Okay. Okay, so Ms. Leger, if you could do me a favor and read back what we have as the current motion, because I think we need to amend it, but I don't remember where it stands at the moment.
All right. All right. Moved by Chair LaHood that we ask the district attorney to verify that a comprehensive search of department's communications has been done and to search for communications to and from Chesapeake Dean regarding Thomas Osley and include but not limited to email, signal, and other messaging apps, and request the conversation settings within the department and the results to be forwarded to the task force administrator to be reviewed at the next CAC hearing.
Okay, and so on the part where we say, and the conversation settings, we want to know the conversation settings for any conversations, that included Chesapeake Dean.
Shall I read it back?
Sure.
Chair LaHood moves that we ask the district attorney's office to verify that a comprehensive search of department communications has been done and to search for communications to and from Chesapeake Dean regarding Thomas Osley, including but not limited to email, signal, and other messaging apps and request the conversation settings for any conversations that included Chesapeake Dean within the department, and the results are to be forwarded to the task force administrator to be reviewed at the next CAC hearing. Does that make sense?
Yes, and to be forwarded within 2 weeks.
Okay.
Okay, that is the very lengthy motion.
And who seconded that?
No one yet. Do we have a second?
I'll second that. This is member
Okay.
neighbors.
Member neighbors seconds the motion. I'd like to open this up for public comment. Are there any members of the public who are not party to this case who would like to make public comment?
Yes, please.
Anonymous, please.
Okay, I heard the first person, then I heard anonymous. Is there anyone else who wants to be in the queue? Okay, we're going to let the first speaker speak. If you could just wait one moment, Ms. Leger will set the timer and let you know, and then after that we'll have anonymous, and then I will make one more call for speakers. So Ms. Leger, when you are ready.
Mr. Warfield, are you first?
I believe so.
Go ahead.
The chair would know. This is Peter Warfield, Executive Director of Library Users Association, Library Users 2004 at yahoo.com, and P.O. Box 170544, San Francisco, California 94117. First of all, I'd like to ask for you to either deliver or perhaps agree to reimburse the cost of aspirin for this meeting, which I feel in dire need of. The petitioner, I think, is making a great deal of sense and should be listened to with great care. The first thing to be said is, I think the detailed nature of this motion is potential trouble. Every time you start getting too detailed, maybe you leave out a certain box that somebody has stored things in. Maybe there's a service dog who takes certain things from somewhere and stores them someplace, and it's outside of anything you have mentioned. I think that the complainant has laid out a comprehensive request that's fair and specific, and that's what should be ascertained and verified has been satisfied in order to determine whether this complainant has received what he requested. The other thing is, at the very least, I would change one of the first words in the motion not to verify, because we already have verified that there is something not quite right about this. I would exchange that word at a minimum to say demonstrate. The respondent needs to demonstrate that they have done a comprehensive effort. There are other things here as well. There are questions as to whether, for example, the custodian of public records assisted the complainant under Section C, 67.21C, to assist them if they don't have it or if it's not in a particular place where it might be found. And I don't think I need to read you that. A custodian of any public record, when not in possession of the record requested, shall assist a requested in directing a request to the proper office or staff
30 seconds.
person. There's another very important section, 67.29-7, which requires professionally maintaining records. And the whole question of what that means in this office and in a legal context is very important and relevant. And the whole question of when are things destroyed and so on and so forth, that's section 67.29-7, which I don't have time to read to you, but I highly recommend you look at it. Correspondence and records shall be maintained in a professional manner. That's another big issue. It should be forwarded in full to the task force.
Thank you for your comment. We appreciate it. Anonymous, I think you are up next, and Ms. Leger will let you know when she's ready with the timer.
Thank you.
Go ahead.
Thank you very much. So I would agree with some of what Mr. Warfield has said, especially around Admin Code 6729-7A. It is a critical part of the law that your discovery of what these signal settings are may help determine whether or not the district attorney is violating Admin Code 6729-7A or not as a department head. But I wanted to thank Chair LaHood for digging in deeper when the respondent was giving you nonsensical answers. The Chair LaHood asked a specific yes or no question to the respondent. And that question was, did you search the other employees at the beginning, their signal messages to or from Chesapeake, and you did not get a yes or no answer? And if this was in court, they would be called out for doing it. It's non-responsive, the answer that the DA's office gave you, which is, oh, well, we searched the Chesapeake signal. They should have said, no, we did not search the other employees, which they were eventually forced to admit. And that is a violation regardless of what happens here. And that kind of word games is exactly what the city plays. And it violates the CPRA because the local agency, district attorney's office, was required to produce all records in the entire agency's constructive possession. And so if the query was messages to or from Chesapeake, you don't just search Chesapeake's inbox and sent, you also search everyone else's inbox and sent that matches that query. And the fact that they failed to do so and that maybe records were destroyed because of that is itself a violation. And that is, I'll get you the citation when this goes to the full task force, but it is a violation in and of itself, even at the CPRA level, regardless of the Sunshine Ordinance. So thank you for kind of hounding them on this because they were almost able to get away with it. Thank you.
Thank you. Are there any other members of the public who wish to make comment on this motion? If you need to unmute yourself, press *6. Okay, I am not hearing anyone else. Members, do we have any other discussion or modifications, or are we ready to proceed with this? Okay, thank you everyone for your comments. I think we are ready to call the vote.
Chair LaHood?
Aye.
Chair LaHood, aye. Member Neighbors?
Aye.
Member Neighbors, aye. Member Wong?
Aye.
Member Wong, aye. I'm going to read this back. Moved by Chair LaHood, seconded by Member Neighbors, to move that we ask the District Attorney's Office to verify that a comprehensive search of department communications has been done and to search communications to and from Chesapeake Dean regarding Thomas Osley, including but not limited to email, Signal, and other messaging apps, and request the conversation settings for any conversations that included Chesapeake Dean within the department, and the results to be forwarded to the task force administrator within 2 weeks to be reviewed by the next Compliance and Amendments Committee hearing. Is that correct?
That sounds correct.
Okay.
Okay. I want to thank the petitioner and the respondent. We appreciate you being here and answering all of our questions. And we also appreciate you providing the information requested within the next 2 weeks so that we can keep things moving. We have just finished item number 6. For those of you who may have joined us late, we're going to be taking a 10-minute break. We will be leaving. I believe the recording will continue. The line will remain open. We will be gone for 10 minutes. Right now, I've got 7:13. Let's return at 7:24. Does that work for everyone? Okay. And for those, I would recommend everyone mute your phones. And if you're on video, hide yourself, and see you back at 7:24. Okay. This is Chair Lila LaHood. I see committee members Wong and Neighbors here. I'm not sure if Ms. Leger is back yet, but for anyone else who is waiting for the meeting to start, again, we have not yet started, but we should be returning soon.
Okay, I'm here, Lila.
Okay, great.
Do we want to call item number 7?
Yes, please. Let's restart the meeting, and please call item number 7.
Item number 7, file number 20134, complaint filed by Mark Sullivan against the Office of Economic and Workforce Development for allegedly violating Administrative Code Section 6721 by failing to respond to a public records request in a timely and/or complete manner.
Okay, thank you. I first, of course, want to ask, is the petitioner here? Mr. Sullivan, are you here? If you're on the phone and need to unmute yourself, please press *6. Okay, since we did take a break, I'd like to give this a minute. Ms. Leger, had you heard from Mr. Sullivan about his plans to attend the meeting today?
No, I didn't hear anything. I sent him a notice of appearance, and I sent him a the link to the agenda. So
okay. Is the respondent here or someone representing the department? Okay, just to be clear, so everyone knows.
Yes, it's Mary Ann from OEWD, and I'm here.
I'm sorry. You know what? We heard you speaking in the middle. Could you identify yourself again?
Yes, I'm so sorry. That was one of my tech challenges. I unmuted myself with the *6, but then I forgot to unmute my phone. So I'm Mary Ann Thompson, and I'm here, and I am with the Office of Economic and Workforce Development, and apologize upfront for not being tech savvy.
Well, we appreciate you being here. Thank you. And I just want to ask again, Mr. Sullivan, if you are here and can hear us, we have not heard you yet. If you are available and can press *6 to unmute yourself, we'd like to know whether you are here. Okay, unfortunately, we're not hearing from Mr. Sullivan. So Mark Sullivan's complaint against the Office of Economic and Workforce Development. Mr. Sullivan, this is last call. Okay, I'm sorry to hear that. We get things on the agenda because we want to have hearings on these matters. Committee members, I am thinking that since Ms. Leger did not hear from Mr. Sullivan, it seems that we should just continue this to our next meeting. And Ms. Leger, if you could get in touch with Mr. Sullivan and I hope find out what happened, and we would be happy to hear his case as soon as he is available.
Chair LaHood?
Yes.
This is Victor Young. I believe it's our standard practice to table or file a matter when the complainant does not show up without providing prior notice. And if they do contact us, we will happily reopen it within 60 days.
Okay, so if we table the matter, may we still reach out to Mr. Sullivan to proactively?
Yes, it is our standard practice to reach out and find out why they did not appear and ask if they intended to continue it. And if they do, we will automatically reopen it.
Okay,
it's just
that is our intention.
Matters and leave things in limbo.
Okay, that is our intention. We will table this matter and Ms. Leger will reach out to Mr. Sullivan and find out whether he would like to continue this matter at a later date.
Okay, but that's a motion, so who's moving?
Okay, I just made a motion since I said it. That is my motion. Do we have a second?
This is Member Wong. I will second that.
Okay.
Motion to table the matter and allow for communications from the petitioner.
Yes. Okay, so we have a motion. We will take public comment. Since we have a motion, we will take public comment on the motion. Would anyone like to make public comment on this motion?
Anonymous,
Yes.
please.
Okay, I heard anonymous, and then I heard someone after that. Do we just have 2 speakers, or is there anyone else? Okay, we're gonna start with 2. I'll ask again. When Ms. Leger, I think you know the order you came in. Ms. Leger will let you know when she's ready with the timer.
Mr. Warfield, would you like to go first?
I believe anonymous was first this time.
I believe anonymous was first.
Anonymous, do you want to go first?
I'm happy to do so.
Okay. Go ahead.
Thank you, and thank you to Mr. Warfield for your courtesy. So I don't know what the complainant's intent is regarding whether he's continuing with this complaint or not. What I can, and I don't in any way speak for him, what I can say is I know what the complaint is about, the records that were requested, because I essentially was making very similar records requests, but long after he did, and they're essentially to prove what happened with the Green Benefits District's requests and complaints about Mr. Hooper that have been pending for years before this task force. And what I can tell you is, for whatever reason, and that reason is not known, but I'm sure it'll come up with either this complaint or in the complaints 19061 and 19062 from Mr. Hooper, we now know that OEWD did in fact produce records to me for some reason in my requests that are predated to the original requests of other people that were not produced to them. And we don't know exactly why, and we don't know what happened there. We know that one of the important issues in these Green Benefit Districts records requests from Mr. Sullivan and Mr. Hooper were the financial kind of trail, the audit trail, the contracts, the deliverables, the actual financial transactions, the funding requests. And until just a few days ago, they were not produced to either me or Mr. Hooper until I made a specific request to go look at this one specific financial system that you have called Total Grant Solution. And there is no need, and it is not required, that we needed to know that the code names of the financial systems that OEWD has. So their prior kind of arguments OEWD gave to you in the Hooper case is that, well, these records, there are no more records. Nothing else exists. We've given you everything we have. They were absolutely wrong. And I hope, whether it's Mr. Sullivan or Mr. Hooper, someone gets justice here, because it shouldn't take a third yet person to make dozens more records requests to finally get to the bottom of something that 2 other people wanted years ago. Thank you.
Thank you for your comments. We'll have Mr. Warfield as soon as Ms. Leger is ready with the timer.
Go ahead, Mr. Warfield.
Thank you. Peter Warfield, Executive Director, Library Users Association. Library Users 2004 at yahoo.com, and also P.O. Box 170544, San Francisco, California 94117. First of all, I want to thank the chair for making what seems to me to be a very sincere and somewhat time-consuming but fair attempt to find out what's what and who's who, and in particular whether somebody is present or not, giving them plenty of opportunity, hopefully, to make themselves known if there's some problem. The procedures do exist, and I think that Mr. Young has cited them. There are procedures in existence that do provide for what happens when somebody doesn't show or when somebody requests continuances. And so I'm sorry to say that I have to agree with the motion. The reason I say sorry is this. I think that the Sunshine Ordinance Task Force has very, in some respects, onerous requirements on the public, on the complainants, that are not really fair, in the sense that, for example, you don't ask people whether they are available for a hearing or even whether they got the notice There's no discussion two ways about scheduling hearings with folks. There's no choice on their part. And the requirement to have a person present who's made the complaint makes anonymous complaints, for example, right at the start, very difficult, if not impossible, and also is not required by law. In some cases, the person may lay out very plainly and very simply what the complaint is and may not need or want to show up for any further discussions. Obviously, it's probably helpful to have the complainant there, but it's not required by law. What is required by law when you do have a hearing, and it's in section 6721, is that the respondent send somebody. That is required. So I'm disappointed that the procedures enable a kind of delay when, in fact, perhaps hearings should go forward in the interest of justice and of timeliness. But in any case, on the understanding that Mr. Young is correct, and I think he probably is, I don't think you have a lot of choice but to go ahead with the motion as it is stated. Thank you.
Thank you for your comments. Is there anyone else there who'd like to make public comment on the motion to table this case? Hearing no further public, oh, sorry, is there someone there who'd like to make public comment? No, okay, I think that was some background noise. I think we're ready to call the vote on this one.
Member LaHood? Chair LaHood?
Aye.
Chair LaHood, aye. Member Wong?
Aye.
Member Wong, aye. Member Neighbors?
Aye.
Member Neighbors, the motion to table the matter and allow for communication from the petitioner on their availability for the next hearing.
Thank you. I appreciate that. And to the respondent, thank you for showing up, Ms. Thompson. We'll be in communication with you. I'm sorry that we weren't able to handle this matter today, but we appreciate your participation and that you were available for this hearing.
Okay, thank you.
Okay. Let's please call the next item.
Item number 8, file number 19140, complaint filed by Stephen Malloy, excuse me, against the Department of Human Resources for allegedly violating Administrative Code Section 6721 and 6725 by failing to respond to a request for public records in a timely and/or complete manner.
So, of course, the first question is, Mr. Malloy, are you here with us today?
He did email me saying that he might have to leave at 7 o'clock because he has another meeting he has to go to, but he wasn't sure.
Okay. I'm gonna wait for a second and see, just because we had issues with people being on mute before. Remember, if you want to speak to us, you need to press *6 to unmute yourself. Is Mr. Malloy available?
He did say that the committee could go ahead with the proceeding if he wasn't available.
Okay. Do we have, actually, I believe Mr. Wazinski was here earlier. Mr. Wazinski, are you still here?
I am still here, yes.
Okay, great. Okay. Thank you for being here. We appreciate your participation. Since the petitioner said that he was okay with us proceeding, and since we were seeking additional guidance, committee members, I can report back to you what I can provide additional information about this, and perhaps we could proceed. How do you feel about doing that, even though Mr. Malloy is not here?
I felt good about it since he said that it was okay. Okay.
So we had some additional questions regarding. So this case has already been heard by the full task force. We found a violation. We referred the matter to ethics. We're still seeking response and responsive records, and we have had some response. Also, Mr. was now I'm afraid I'm going to say your name the wrong way. Mr. Wazinski is new in his position and has been appearing at the hearings, which we appreciate because that was we had previously had some issues with the department not sending representatives, so we appreciate him being here. We had some questions at our last hearing about redactions regarding items that were considered attorney-client privilege. So based on some advice that I've received, so a document may have attorney-client privilege. That does not mean it's not a public record. So we can have a public record that is that the person, that the respondent or the department that it's being requested from may say, we are withholding this information for attorney-client privilege. And it is the burden is on them to support that. And one of part of Mr. Malloy's request was about the metadata and the citation on the redactions. And I know that at least one of the documents that was provided is just blacked out text. So it's that the document was redacted in full, citing attorney-client privilege. It seems that even though the information within the document and perhaps the subject may be redacted for attorney-client privilege, that at least some of the metadata, including the to and from, and perhaps the date and time, should not have been redacted unless there's a clear case that can be proven as to why that was redacted. Because if the search was done and this record was returned, and especially since if the attorney-client privilege is, the advice that has been given to us is that if he is also requesting the metadata, unless there's specific reason for the to and from and the date and time, perhaps even things like the size of the file and whether there are attachments, that information cannot be withheld. Perhaps the name of an attachment can be withheld, but not the fact that there are attachments. Committee members, does this make sense to you? Does this provide, do you think, the additional information we needed to proceed with this? I'm seeing heads nodding. Do you have any other questions, or should we give Mr. Wazinski a chance to respond?
No questions for me.
Okay. Would you like to respond to what I've just said before we proceed with making a decision from our last meeting, which we were not able to make because we needed additional information?
Sure, yes, I would like just a brief response. Firstly, thanks for looking into this. I mean, from our perspective at DHR, we were, mostly just kind of waiting on you to tell us what we needed to do. Mm-hmm. So that's fine. From what I've heard so far, makes complete sense. I believe, and I don't know if you're planning on touching on this also, but I believe another part of Mr. Malloy's request was he was of the opinion that there were other, and can you hear me okay? I'm getting a little bit of feedback.
We can hear you. I am also hearing the feedback, and I feel like this started when we returned to the meeting. I'm not sure what's causing it. I'm going to put myself on mute and let you talk. Maybe that will help.
Okay. Anyway, yeah, maybe it's better. I'll just continue. I believe Mr. Malloy was of the opinion that there may have been other documents that we, didn't find that were withheld. And another part of the issue was whether we were going to have to conduct this search anew, looking for other documents. What was kind of the second part of what we had to decide on as well. So, yeah, that's all I have to say on that. Thanks.
Okay, thank you. We appreciate your comments and your willingness to take our guidance on this. I think it'll make everything a lot easier. So committee members, how I know we had much more conversation on this at our last meeting. How would you like to proceed at this point? I mean, I think at minimum, it seems that we should ask for, I think we should ask for either justification for why there was full redaction on some of what was returned, or to have that information revealed, especially when it comes to the to from fields, the date, the time. The subject, if it's determined that the subject does not fall under attorney-client privilege, or is, if that's something that, I would say anything that can be revealed should be revealed. Anything that does fall under attorney-client privilege and can be justified should be, we need citations for that. Do we also want to ask for a new search to be done, given that there's someone in this role who perhaps could do that with the thoroughness that Mr. Malloy feels was lacking in earlier searches? What do you think about that?
Yeah, I think that's a good idea. I think all of this maybe start the search over. Definitely, it sounds like we have agreement now about like the full page redaction. I'm curious about what kind of citations will be acceptable for our respondent to make clear and to show legitimacy in protecting attorney-client privilege. Mm-hmm. I think that's always an issue that keeps coming up over and over. And if you have any additional learnings about that since last time we talked about it, or any guidance from him, I think that would be useful as well.
Yeah, I mean, I think at minimum the to from, because then there's, at minimum we can see that it's, to or from the city attorney, and I think that would help to some degree. I think probably I do think, and have not discussed this with Mr. Malloy, but knowing the timing of these discussions, I would think would be helpful for him. And then knowing. And I know that the department responded that in their initial letter that they didn't have that their search did not return a lot because Mr. Malloy was working as a contractor, but he had some doubts about how that search was conducted. So if there's a representative who is willing to redo the search, I think that would be I think that would be helpful.
Yeah, agreed.
Okay. Member Wong, anything to add on that?
No, I agree with everything that you've said.
Okay. So hang on one second. So, Mr. Wazinski, would this be, if we proceeded in this fashion, it sounds like you would be amenable to returning the requested information back to our administrator, so that we can so that we can send it to Mr. Malloy and ensure that there's a compliance with our order?
Yeah, sounds great.
Okay. I have made a lot of motions today. I'm going to give the opportunity to one of my fellow committee members to make the motion on this matter. unless you really want me to do it. Maybe this is my day. Okay. I am making a motion to request that the Department of Human Resources review the documents it has presented with redactions on the basis of attorney-client privilege, and to reduce the redactions only to material that is truly covered by attorney-client privilege, to justify and justify those redactions, cite the reasoning, not redact things, particularly in the metadata and headers that does not need to be redacted, and to do a new search based on the original request to see if there are any additional responsive documents. How do we do? Was that clear, or was that too wordy?
It was long.
It was long.
Yeah, because I'm trying to type it verbatim so that we get it right.
Oh, okay. I thought you were okay.
No, I want this thing to be clear. To be absolutely clear.
Can you read back what you have, and perhaps we can edit it?
Yes. Chair LaHood moved to request that the Department of Human Resources review the documents it has presented with redactions on the basis of attorney-client privilege to justify those redactions. Then I didn't hear part of it, and I said to redact things and metadata and headers and complete a new search to locate additional responsive records. So there was something in the middle of that I.
Yes. Okay, so the middle part was. Forgive me, read the first part again, and then I can restate the middle part.
Yeah. Moved by Chair LaHood to request that the Department of Human Resources review the documents it has presented with redactions on the basis of attorney-client privilege to justify those redactions.
Right, and to remove redactions.
Yeah.
Let's see, to remove unnecessary redactions on header fields such as to, from, date, time, and any other fields not covered, not justified by attorney-client privilege. And we might say including but not limited to.
Okay, because that's changed from what you said originally. Motion to request that the Department of Human Resources review the documents it has presented, excuse me, with redactions on the basis of attorney-client privilege to justify those redactions, and to remove unnecessary redactions on header fields, to redact things on header fields, and then what?
Okay, on header field, okay, to remove
unnecessary redactions on header fields, including
such as, yes, including but not limited to, from, and date and timestamps.
From, let's see, but not limited to, from, and date and timestamps, and to complete a new search to locate additional responsive records.
Yes.
So read the whole thing again?
Sure.
Okay. Moved by Chair LaHood to request that the Department of Human Resources review the documents it has presented with redactions on the basis of attorney-client privilege to justify those redactions, and to remove unnecessary redactions on header fields, including but not limited to, from, to, date, and timestamps, and complete a new search to locate additional responsive records.
Yes, I mean, to complete a new search, to determine, yes, to, you know what, I like the way you've worded it. I think that is sufficient.
Okay.
Do we have a second on this? Or is there anything that members that you would like to add or modify?
Nothing to add. I'm happy to second.
Okay.
Who wants to second?
That was member Neighbors who seconded.
Laurie, your second?
Yes, ma'am.
Okay. Terrific. Okay. So do we want to take a vote on this?
No, we want to open it up for public comment. Yes. So anyone who is still with us on this call, remember *6 to unmute yourself. Would anyone like to make public comment on this matter, on this motion?
Yes, I would, actually.
Okay.
Please.
I heard one person. Is there anyone else who would like to make public comment on this?
Anonymous, please.
Okay. We'll take the first speaker, then anonymous. Ms. Leger will tell you when the clock starts, and I will make one more call for public comment after these two speakers. Ms. Leger, whenever you're ready.
Is the first speaker ready?
Yep.
Go ahead, sir.
Thanks. And I'm not sure if, this is something that should just fall under public comment, but it's sort of actually maybe some more questions about the determination that you received from, your legal counsel considering the attorney-client privilege documents. Is there maybe a certain administrative code that the legal counsel cited when they made this determination that maybe I could look into as a reference for more guidance onto why that specific decision was made about this metadata? And another point is, for these attorney-client privilege documents, hypothetically speaking, if these documents were entirely protected under something else, say if they pertain to maybe like an equal employment opportunity case file, and were therefore not disclosable as a public record, I guess how it, does the same metadata determination apply to those as well? Thanks.
Thank you. We're going to take all public comment before we say anything else. If the next speaker is ready, Ms. Leger, we'll take your cue.
Okay.
Next speaker ready?
Yes, I am.
Go ahead.
So first of all, it's unclear. Was the previous speaker the actual respondent? Because if they were, then I don't think they were supposed to speak during public comment. It seemed like they were asking you what to do. But regardless of that, I think this is a great motion. I think that the thoroughness and detail of this motion is what I wish every motion, and the motion you made 2 cases ago is what every motion at the full task force reaches, because if the original orders of determination are very precise and specific, and you all, 11 of you, spend hours formulating those orders of determination at the full task force, I think your primary work product should be this specific. And I think I'd urge you to spend the extra few minutes at full task force to make those kinds of orders of determination to help create your, your precedent, your ruling, so people know in the city and the public what is disclosable or not. And finally, with regards to the last commenter, regardless of whether that is the respondent or not, your DCA's ruling is exactly right. It's what your attorney member Schmidt mentioned at the very beginning of this case, that there's no reason not to disclose that, this is actually a communication between a non-attorney and an attorney for advice. And I now understand why Mr. Malloy was so vocal in support of my metadata complaints, because metadata is not some random thing Anonymous cares about because he's a software engineer and wants to get into the technical details. It's because metadata allows you to know whether the city is lying or not. And that's why it's so important that metadata be disclosed even when the contents cannot be disclosed. Finally, the equal employment thing mentioned by the previous commenter, they're willing to bring you a legal citation that says that's not a public record. Because again, it would be a public record. Maybe it's non-disclosable under certain privileges or some federal or state law, but that doesn't make it not a public record. People need to read what the definition in the PRA is of a public record. It exempts almost nothing. Almost everything in the government's possession that is not, quote, purely personal is a public record, and then it must be exempt under some other law. And so everything your DCA said is spot on. And I'm happy that even if the rest of her office doesn't understand it, at least your DCA does. Thank you.
Is there anyone else wishing to make public comment on this motion? And remember, you have to press *6 to unmute yourself so that we can hear you.
I think I was on. Yeah.
Okay, we can hear you now. Would you like to make public comment?
Yes, please.
Okay, wait, Ms. Leger, we'll tell you when she's ready with the timer, and then you may speak.
Go ahead.
This is Peter Warfield, Executive Director of Library Users Association, Library Users 2004 at yahoo.com, also P.O. Box 170544, San Francisco, California, 94117-0544. First of all, we support the motion, basically. I would say, and it does reflect on other sorts of cases, and as one of your members said, these kinds of things keep coming up over and over again. So I'd first of all like to agree with Anonymous, and who just spoke prior to me. One of the things I would like to know is, first of all, where is the city attorney who is supposed to be devoted to the Sunshine Task Force, and why are the opinions of the city attorney, which evidently were orally conveyed to the chair, not written down, and in any case not documented where everybody can see what they are and whether they agree or disagree, and in any case just what they are. It's very disconcerting that there seems to be so much that has been taken away from the Sunshine Task Force with respect to support and the corresponding openness. The city attorney used to write a letter basically outlining cases previously, and it was always in writing what the legal issues are and so on and so forth. I can't say that we always agreed with them, but at least there was something there in writing, and it represented a certain amount of effort. So, for example, why is there no subject line? What's wrong with saying that this is about such and such a case without giving away what the opinion is about the case? And yes, anything that would bear on possibly understanding better what's going on and whether, as Anonymous says, it's legitimate, I think would be important. But I think a subject line would be important too, and wouldn't necessarily give away what's going on. I appreciate the efforts that you guys make to dig and to uncover and to clarify. I think that's very valuable and very important. And what certainly Anonymous said is the better that is documented, whether it's minutes or orders of determination, the more valuable it absolutely is for everybody concerned. So I hope you continue in that vein, but also add more information to be requested, such as I think subject line, I think would be valuable and not necessarily giving away the advice. Thank you.
Thank you for your comments. Is there anyone else on the call wishing to make public comment on this motion? Okay, seeing none, just in response to one of the questions about how this applies, and I think one of the other commenters elucidated a bit, but if just because there's attorney-client privilege doesn't mean it was a public. We can have there can be public documents that are protected by attorney-client privilege. Because of the redactions, redactions should be kept to a minimum. Attorney-client privilege can be used as justification for withholding or redaction, but it needs to be justified in each instance, and it needs to be precise and not overly broad. You can't just put an umbrella over everything. And again, in the case where the to and the from does not need to be protected, it should not be withheld. And as far as the subject line, I gave that as an example, but this is why I said not to be limited to, from, date, or time. But those in particular seem to be ones that could be revealed without, unless there's a really good reason for withholding those according to attorney-client privilege. It seemed that those in particular should be released. Members, do you have anything else to add on that, perhaps based on your experience, that would offer guidance to the public? No. Okay. Are we ready to call the vote on this? I think so. Okay.
Chair LaHood?
Aye.
Chair LaHood, aye. Member Neighbors?
Aye.
Member Neighbors, aye. Member Wong?
Aye.
Member Wong, excuse me, Member Wong, aye. Moved by Chair LaHood to request that the Department of Human Resources review the documents it has presented with redactions on the basis of attorney-client privilege, to justify those redactions and to remove unnecessary redactions on header fields, including but not limited to, from, and date and timestamps, and complete a new search to locate additional responsive records.
Thank you. And thank you, everyone, for participating, for the Department of Human Resources for sending a knowledgeable representative, and for working with us on this case, and to the public commenters. Let's call the next item.
Item number 9, announcements, comments, questions, and future agenda items by members of the Compliance and Amendments Committee.
Members, what would you like to discuss?
This is Member Wong. I just wanted to say really quickly, kind of on the topic of SB 1421 and police records, I started listening to a new podcast that's been put out by NPR and KQED called On Our Watch, and I just wanted to bring it up and recommend for the members of the public, as well as members of the committee, and possibly the full task force in the future, to have a listen. They've only put out one episode so far, but I find that it intersects the work that I'm doing here on the task force, as well as the work that I'm doing with the League of Women Voters, and so wanted to mention it.
Thank you for the recommendation.
What was that podcast again? I'm sorry, I didn't hear that.
On Our Watch.
Is there a time? I guess top podcasts you can listen to it at any time.
No.
I don't know how they work, to tell you the truth.
The time is when you're doing your dishes.
And KQED makes it into the minutes. Anything else that you want to discuss? I'm trying to remember back, and forgive me, I was focused on preparing for the cases we had today. Member Neighbors, please go ahead.
I believe it was Mr. Warfield who asked a question, and it's a question I've had as well. So I wonder if it's something I just missed along the way. I've heard other members in full committee mention it, but so are we no longer having city attorney representatives at our meetings anymore? Is that temporary? Is it permanent? Can you just explain the status of that?
Yeah, I can address that, Lila.
Okay,
sure.
I apologize. Yes, at this point, we are not receiving any more city attorney memos. And the city attorneys our city attorneys, Helen Castillo and Mark Price Wolf, are present at our task force hearings. That's it. And if you need guidance, or if you have a question or you need guidance on a specific issue, they welcome you to write an email or pick up the phone and call. And it's probably easier to write an email. That way you can be clear on what you need and they can respond to you.
Okay. So to be clear, Member Neighbors, we used to get memos analyzing each complaint that came through. We are no longer getting those, but they have been responsive if we have specific requests. So, you know, if you have questions on your own, you're welcome to reach out to them. Or like in this last instance, you know, we decided as a committee that we needed more information, and I reached out this time. But next time I might ask one of you, could you follow up with them, because we'll need this for an upcoming hearing. And I believe, yes, Mr. Warfield brought up, there's always discussion about resources and what's available to the task force, and more would always be better. But our current Ms. Leger described our current circumstances. So this is where things stand now. But again, the attorneys assigned to work with us are very responsive and helpful. So if you ever have questions, don't hesitate to get in touch with them.
And so when they're with us in the meeting, they're just monitoring. We can't ask them.
No, we can.
You can.
Yeah.
Full task force hearings.
Okay. Okay, that's good to know.
Yeah. The other thing I was saying is I remember a few meetings ago we had talked about, and perhaps for our next meeting, I will go back and look at the minutes to see. I think there were some other issues that we were going to do some research on, and I can't recall those off the top of my head, but I will go back and look at those unless there are any that you remember or that you have been looking into that you want to make sure that we put on the agenda for a future meeting.
The one that I recall is the one that you brought in today, the wanting to get more clarity around attorney-client privilege and understanding how we can, that idea of like anyone can say like, sorry, it's attorney-client privilege, we can't show you. How do we actually probe that and make sure that that's not an abused concept for people when it comes to public records?
Right, and it keeps coming up, and it's it's I'm happy that we are learning more with each case, and I appreciate the guidance that we're getting, and I hope that is useful for petitioners when they're seeking information or in the event that they need to file a complaint. So do we have anything else to say, or should we? I guess we could take public comment on this.
Yeah, you're waiting.
Yes, one last call for public comments. Would you like to make public comment on this?
Yes, please.
Okay, one moment. Is there anyone else who wants to make public comment on anything we've just discussed?
Yes, anonymous second, please.
Okay, so when Ms. Leger is ready with the timer, we'll take the first speaker and then the second anonymous speaker. So Ms. Leger, I'll let you give the signal.
Mr. Warfield, are you ready?
Yes.
Go ahead.
Thank you. Peter Warfield, Executive Director, Library Users Association. We can be reached at libraryusers2004@yahoo.com and also by mail at at the U.S. Postal Service at P.O. Box 170544, San Francisco, California 94117-0544. First of all, I think that all of the things that were brought up here were excellent, valuable, and urgently needed. What's attorney-client privilege allow to be redacted or withheld completely? That needs to be a full discussion, full presentations of whatever kind, and full public discussion, and then I think perhaps a report. I don't want to put anybody to a lot of extra work, but I don't think it would be extra work. I think it would be very valuable work. And if the minutes were well written up and the presentations were good, I think that would be very, very valuable. I'd also remind you that Anonymous has filed many complaints which have shown when comparing your decisions versus the city attorney, that the city attorney isn't always quote unquote right about everything that the city attorney does or opines on. Second of all, I've commented in general, certainly with respect to compliance, I think you need to have a serious discussion about what everybody recognizes is a very weak enforcement position that the task force finds itself in. But you need to face that. Just going along and struggling along and doing the same things again and again, I think is problematic. I think there's quite a bit of new blood on this body, and there's a lot of promise here. And I think that there could be some serious value to considering the whole question of enforcement. I can say that a very long time ago, the task force had a website basically that gave a lot more information and was a lot more maybe journalistic about what happened and what decisions were made and what decisions had come out. I certainly think that putting better publicity out with respect to violations, both
30 seconds.
Giving full details about what you considered was wrong and putting them out on the web, for example, or in very extensive and more extensive reports would be tremendously valuable toward having a kind of moral weight, even if you don't have some kind of physical, cops coming in with batons. I think that would be extremely valuable and worth discussing on an agenda item in the future. Thank you very much, and thanks again for your attention to everybody's rights and everybody having a chance.
Thank you for your comment. Anonymous, Ms. Leger will let you know when she's ready with the timer.
Go ahead, Anonymous.
Thank you. As I often do, I'll second everything Mr. Warfield just said. I think I agree with all of his points. In terms of how certain specific things you all mentioned in this section, I think that the attorney-client, this issue about attorney-client privilege, what it does cover versus doesn't cover, I think you need to have a full task force presentation, as mentioned. I think that some things are so important that having full hearings about them, and they're so wide-ranging, should happen. And your task force, the last time your task force did this, right, Chair LaHood, remember this, you had 2, possibly 3 full hearings just about metadata because it's such a widespread problem. Attorney-client privilege is at least as widespread a problem as metadata was. And I think that the city attorney's advice to the other agencies through their DCAs does not match your DCA's advice. And they claim such a broad definition of what is attorney-client privilege, and actually even more importantly, what is attorney work product privilege, that it doesn't actually meet the definition in the law or court cases. Kind of anything that even relates to attorney-client privilege is called attorney-client privilege. Things in attorneys' offices that are not actually written by attorneys, they're not the thoughts or impression of attorneys, nor dictated by an attorney, are called attorney work product privilege. And I think your DCA should give you a full presentation on this. The public will learn as well. I would also ask that you make these email exchanges waive the attorney-client privilege in that advice from the city attorney's office and publish them in your administrator's report or maybe the chair's report. You have the authority to do that. You did that when I asked you, but you should do it also not automatically, at your own will, because it's in the interests of transparency that the public knows what is the advice of this DCA telling you about how you can disclose to and from, even if you can't disclose the body, for example. So that's an action item I would ask you to place either on your own agenda or the full task force agenda, a presentation of attorney-client privilege, and also a motion for waiver of the attorney-client privilege in this advice that was received by this committee about what attorney-client privilege is and how it relates to and from. Thank you very much.
Thank you. We appreciate your comments. Is there anyone else wishing to make public comment on this last item? This is last call. Press *6 to unmute yourself. Okay. I think that is it. I'm going to assume that anybody left on here who wanted to speak got a chance to speak. Again, everyone, thank you for participating with us. We appreciate you being here for the Compliance and Amendments Committee hearing. Fellow members, thank you for being here. Ms. Leger, Mr. Young, thank you for being here. Are we ready for the last item?
Yes.
Item number 10, adjournment.
Do we have a motion to adjourn?
I'm going to adjourn the meeting.
Do we have a second?
Seconded.
Okay, we can take this by acclamation. Thank you, everyone. Ms. Leger, are we finished with the recording?
No, I haven't turned it off yet, but I will. So we're concluding the hearing at 8:18.
Okay, great.
All
Thank
right,
you, everyone.
I'm turning off the recording.
All right.